Okay. Was that traffic? Um, All right, in regard to case number 2020 CT 755A, that's going to Division 85. It was a failure to appear on a leaving the scene of an accident case. Bond amount is 1,000. And let's appoint the public defender if they were not already appointed.
And I'll waive the appearance, Your Honor.
Okay, I think that's all we have on him, right?
Yes, Your Honor.
158. Okay. Thank you. And is this Mr. Keith?
Yes,
All right, sir, thank you.
all applied sciences. I was just supposed to say all applied science, imply all science.
Okay, let's see where we're at on this. We have a new trespass case, 2021 MM 319AW. It's going to Division 85, and if you need a public defender, sir, we can appoint their office to represent you.
Yes, Your Honor. He has been deemed incompetent to proceed by Dr. Ruiz May 8th of this year, 2021, in his out on bond case for trespass after a warning. An ROR was granted by the last judge based on that incompetency. So I would just ask that because it's nonviolent, it was at 7-Eleven that you grant an ROR in this case. He is unemployed and he is unable to pay for bond.
What's the state's reaction?
Your Honor, just because he's been deemed incompetent in the lower case doesn't mean he's been deemed incompetent in this current case. I do see notes that he's been determined to be incompetent in 2018 and mentally unable to stand trial. So I do believe it's been an ongoing issue. His history generally seems pretty nonviolent, mostly trespassings and it looks like drug-related things. State has no objection to an ROR, Your Honor.
Well, you know what happened, one of the problems is, counsel, is that once we ROR him, there will be a failure to appear, and then, he'll just be back on that. And I guess you all can deal with it at that time again?
Yes, Your Honor. Normally what happens is if he's not, he's gonna sit in here because he has no way to pay bond.
Well, it'll be sooner or later, because sooner or later, somebody will just, he'll come in on the weekend, they won't know, and they'll bond him over on his failure to appear, so just, I don't know I don't know what the answer is, but if you all want me to ROR him, I'll do it for now, I'm just telling you.
I plan never to go back there again.
Your Honor, state would just ask for no return to the 7-Eleven.
All right, so ordered, thank you. Sure, we'll let you out, but try to meet your court dates, because otherwise I'll pick you back up.
And no action on the,
Just,
Right, thank you.
I don't have the rest of it. I can pull it up if you want to look at it.
Is this Mr. Hutchinson?
Yes, sir. Ma'am?
That's okay, thank you, sir.
Welcome.
We have some out-of-county warrants. In regard to some sex battery charges. And primarily some of these are at no bond in Hillsborough County, basically. And so you'll need to be taken over there. It doesn't take too many days. Once you get over there, they'll read out the charges for you and appoint public defender if you need one.
I already have a lawyer.
Okay. All right. Well, at the moment, it's just no bond until you get to Hillsborough County, sir. That's all we have for you today? Okay, are we back to the regular? Spanish, okay. Mr. Jimenez, right?
Good morning, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter, previously sworn.
Thank you, Mr. Morales. We have is it just one person today? Or no, several people. And the first person is Mr. Jimenez with the first new case, 2021 CF, 6173. And I'm not seeing any witness here. Let's appoint the public defender to represent him. It's going to Division 11. The allegation on the current charge was burglary of an occupied dwelling. They have probable cause. He's also out on bond, and that's a different situation, but for the burglary of the occupied dwelling, let's set bond at $3,500. 100 on the criminal mischief, 100 on the stalking, and require, maybe this is obvious, but no contact. Don't return to the scene. If you have any guns, knives, or weapons, put those in the care of law enforcement within 24 hours of your release for safekeeping. And there's a couple of cases for which he's out on bond. Possession of cocaine resisting, possession of heroin, I think is 2020 CF 6680, and possession of alprazolam and DUI is 2020 CF 14874. To be honest, in regard to the prior history, as well as concerns in regard to the new charge and the type of activity which is alleged to have occurred while out on bond on two separate felonies.
I would ask that you revoke.
I was inclined to revoke. There's just too much going on, and the situation appears to be somewhat out of control.
Your Honor, he's also a violent felony offender of special concern.
Yo lo que estaba era tratando de hablar con ella.
Your Honor, I would just ask that if you are inclined to revoke, that you double the bond amount as opposed to holding him at the bond.
Well, I understand the defense's request, and sometimes I do that. But, sometimes it just starts to add up to the point where I want to slow the situation down and let the felony judges look it over. Because, breaking in the back window to get into the house, it just sort of crosses the line in terms of safety and the level of being out of control. So, Mr. Jimenez, we're going to appoint the pub defender. We should have counsel on everything. You now have 3 felonies pending, and I'm just going to try to slow down this train for a moment. Maybe you can take a breath, and everybody can be better protected.
Your Honor, so for the record, both 20 CF 6680 and 20 CF 14874 were both revoked and set at 0.
Right. Your lawyers know how to get you in front of those judges if that needs to be addressed, sir. Good luck. Right.
He's entitled to bond on everything, so I'll just ask for a withhold bond.
Or don't return to the scene, I'm sorry. I think that, yeah, that's obvious, but Okay, we're getting through the Spanish Interpreter Council, then let us know what you're here on. Thanks, okay. Is this Mr. Quinones? Yes, I am. Thank you.
Your Honor, the defendant is saying that he does not need an interpreter.
Sir, we'd put you back into the stack and get to you later. Do you want to get it over with now?
Yes, it will be better for me. Yeah.
Okay, let's just put your earphones back on then.
Thank you.
You're welcome. Okay, so this is Mr. Quinones, and the case number is 2021 MM 3574. We can appoint the public defender to represent you, sir. They have enough information to at least file the charge of domestic battery at this time.
He does qualify for pretrial release. I would just ask for pretrial release, given the lack of criminal history.
And the state's not necessarily jumping up and voicing any concerns.
Your Honor, the state has no objection.
Okay. Now, there's a little bit of history, sir, that we see in regard to domestic battery, but you still qualify for pretrial release, which means you won't have to post bond. However, the requirement, since we don't have a witness at this moment telling us that it's safe, the requirement would be no contact with alleged victims' separate residence for now, until you both get in front of the judge and tell the judge that it's safe. So if you need a police escort to get some things out of the residence, a police escort can be provided. In regard to the child, who evidently is her son and not yours, Department of Children and Families has been notified, and so the contact with that child would be controlled by orders by DCF or juvenile court. If you have any guns, knives, or weapons, put those in the care custody of the arresting agency within 24 hours of your release for safekeeping while the case is pending. Talk to your public defender if you want to change the no contact order. Your wife cannot change the no contact order. You have to go through the judge and the public defender to get you a hearing for that.
No problem. She's already living. Ya está viviendo fuera de la casa.
Right, okay,
No, where she's already living somewhere else.
right. Okay, good luck to you, sir. Oh, I'm sorry, that was PTR. Oh, okay. Okay, Marino Rivas? Okay, thank you. So would this be Mr. Bonet Rodriguez?
Algo poquito, bien bajito.
Your Honor, the defendant is stating that he can hear, but to him it's very low.
Okay. All right, it's Mr. Bonet Rodriguez.
Yes.
Thank you. Okay, the new case is 21MM3568, Division 61. Public defender can be appointed if you need them. The allegation is possession of drug paraphernalia, soliciting without a permit, while being out on bond, for possession of drug paraphernalia, tampering with physical evidence, represented in that case by Attorney David Fussell.
The state did make an offer of an adjudication of guilt credit time served on the new charges of soliciting without a permit and no information for the possession of drug paraphernalia. Defendant speaking Spanish, Your Honor, I did not have a chance to speak with him to see if he would like to accept his state's offer.
Okay, sir. So you've been made an offer on the pending misdemeanors you just got arrested for, and I'm willing to resolve those if you want. But, yeah, and I don't know what your immigration status is, but every criminal charge can result in deportation. Keeping that in mind, as well as the concern that might be reasonable that you need to be careful about getting criminal convictions on your record in general, since they inhibit you from getting good jobs and renting properties, et cetera. Did you want to try to resolve the misdemeanor case today?
Sí.
Yes.
Okay. Now, sir, have you had familiarity with that plea form?
Sí.
Yes.
Okay. If you are familiar with what's on that form and you're willing to sign it, giving up the rights to have a trial or a defense or to have lawyers check out your case, then go ahead and sign the form and we'll go ahead and finish your misdemeanor case today.
No tengo que ir más frente a un juez ni nada, ¿verdad?
So I don't have to go back or be before a judge again, right?
On the new misdemeanor, correct. You still have the case for which you're out on bond and which David Fussell is representing you on. But I will ask the prosecution, sometimes they recommend you not get revoked on that bond if you resolve the new charge. Is that the position? Okay, so in fact, since you're willing to resolve the new charge, I will not take any action to revoke the bond for which you were out on bond, even though it is a violation of the release conditions for the case that you're out on bond for to get a new charge. But when you enter a negotiated plea on the new charge, sometimes we let that one go. We don't revoke you on it. You will still have court dates left in Division 19 with your lawyer, David Fussell, on the old possession of drug paraphernalia and evidence tampering charge. Do you understand that?
No, pero yo quiero que se termine todo esto, que me vayan a dar lo que me vayan a dar. Que yo quiero terminar esto con esto. Yo no quiero ir más frente a un juez. Yo no quiero ir más a un abogado. Nada. Quiero resolver esto hoy.
Well, I want to get this all over with. I don't want to have to go before a judge again. I want to be done with this.
Well, sir, this is not Burger King and you do not get it your way, if you know what I mean. When you have a multitude of cases pending, you have court dates. And if you think it's inconvenient, then it would be ever so much better for all of us that you would stop getting new cases because, in case you haven't noticed, we have plenty of work to do without your return business.
Por eso es lo que quiero resolverlo.
I can finish one
That's why I
case
wanna
for
resolve
you
it.
today. I can't finish them both. This is not Publix. You do not get one, buy one free, or whatever. You still have a felony left over. I don't have a jurisdiction on that. You still have a court date on that one. Do you want to finish the misdemeanor today?
Sí, sí, sí.
Yes, yes.
Okay. Did you understand you would be giving up the rights on your plea form? On the new case, you won't have a trial, you won't have a defense, nobody will have to prove it beyond a reasonable doubt that you had the drug paraphernalia and that you were soliciting without a permit.
Sí.
Yes.
Okay, so we're just taking a plea on the soliciting and not the paraphernalia because that's getting dropped?
Yes, Your Honor, I'm going to announce a no impact. It's an
Okay,
adjudication on that case.
So you're just getting one conviction and not two. And if you were on probation for anything, this would violate your probation. If you're not an American citizen, then this could violate or cause deportation. Do you understand that?
Yo estaba en la sí.
Yes.
All right, sir, I'm going to find that you're alert, intelligent, enter a plea of no contest in a free and voluntary manner to the one remaining charge, soliciting without a permit in the new case. Find adjudicate you guilty of that, sentence you to what probably is 2 days' time, sir? Okay, release you as of this charge. As you probably know, we always impose court costs in every case. Here out of the jail, we generally give you a year to pay in case you're trying to make partial payments, because suspensions on your license occur when you don't pay the fines in these cases. Now, just be aware, we did not resolve the pending felony that still exists. It's in Division 19. It's with Attorney David Fussell, Fussell. You might want to check with him in regard to your court dates. I'm sorry I couldn't resolve everything for you, but you've got a felony still pending.
The state announces a no information as to count one.
All right, good luck to you, sir.
Mira, pero con permiso,
But excuse me,
¿me vas a soltar hoy?
am I getting out today?
Yes, sir. On the misdemeanor, just be aware that your felony case still has court dates. You need to check with your lawyer on that. Good luck to you, sir. We need to move on.
Ok, gracias.
You're welcome. All right, thank you, counsel. And you have Mr. Mustelier?
Yes, ma'am.
All right, we have,
For the record, Your Honor,
yes, ma'am.
I'll wait until you call the case.
All right, the case numbers include 2020 CF 84. Oh, I'm sorry, we don't need the interpreter anymore, Mr. Morales. Thank you so much.
No problem, Your Honor. Thank you.
Thank you. Okay, we have 2020 CF 8473, Division 19, which was a warrant in regard to an allegation from July 12th. And that warrant there might have been a warrant outstanding on that when your client was alleged to have encountered the officers again yesterday in regard to 2021 CF 5116, in which they allege that he was trespassing on a construction site and resisting an officer on, was that the 29th of April? 29th of April. Okay, no, that was a more recent case. That's in Division 22. And the warrant on that one has a $1,000 bond initially set by the arrest warrant for trespass on designated construction site and resisting without violence. But the first case alleges from July an attempted kidnapping, bat strangulation, felony battery, and hindering communication with LEO.
Your Honor, we actually filed an information on that case. So there are actually different charges.
The attempted kidnapping case?
Yes, Your Honor. We filed an information. What we filed was, count one is a F1. It's tampering a witness to hinder communication to a law enforcement, and an F2 proceeding. Count two is an F2, an aggravated battery, great bodily harm. Count three is an F3, false imprisonment. And count four is an F3, battery by strangulation, DV.
Okay. Right, false imprisonment instead of attempted kidnapping, basically.
The F3 false imprisonment and the tampering a witness to hinder communication to law enforcement, and an F2 proceeding, which is an F1. That's what they filed instead of the attempted kidnapping.
Okay.
Your Honor,
Yep.
for the record, I'm Attorney Merrill Glover Gambles. I represent Mestier. I've asked to be provided with a copy of the information, if that's available. And what we want is to be heard as to bonds.
Right, I understand. I didn't check to see if the affidavits for the arrest warrants were of public record. I get them printed out for me, so, sometimes they're public, sometimes they're not. A lot of times they are. Is that what you're looking for?
Yes.
Okay,
But at this point, if there's already a warrant, that means, and they've already filed the information, Your Honor.
well, yeah, they found probable cause.
Right.
However, on these, especially like the battery cases, they come in no bond pending initial appearances.
That's what we want to be heard. We already passed the probable cause, so we would like to be heard as far as.
So, would you like, I don't mind.
Is there a bond on the information? Was there a bond set?
No.
I've got both probable cause affidavits that, I'm not sure that I'm supposed to let you have to take with you, but
I'll get it.
I don't mind you looking at them if you want.
Oh, it's okay. I'll get it in the discovery then.
See, I'm not able to provide them, Your Honor, since I don't believe there's an NOA or a demand for discovery yet.
Well, I'll tell you, then, Ms. Glover Gambles,
Well,
the one from July, the good news is evidently that he didn't have contact with the police again until more recently on, when he supposedly, I think if I'm remembering correctly, the trespass on construction site was supposedly he and a young lady were supposedly smoke a pot or smelled like they smoked a pot, and then he supposedly ran off and ran through a construction site. And I guess he got away, but they evidently figured out who it was by researching the tag on a vehicle, and then probably the guy whose vehicle he borrowed told them who this guy was, and then they looked him up on David and they saw who it was. And so that was the alleged trespassing through the construction site, because he ran through there, and the resisting. Now, but the other one was kind of really scary, but it was July, and evidently he didn't, maybe get the police called on him again for that, but the allegations were the kind that make you worry. If he had just gotten arrested for it, I'd be really worried. But that one was, what was, I had more than one of these, but I think this is one where it was alleged that back in July, he was banging at his girlfriend's front door. Then he ran around to the back, sliding glass door. In fear, she opened it. She thought he was going to break it. And then he supposedly was trying to rip her dress off because he thought that if she had a dress on that she might be going out. And then he allegedly punched her in the face, causing her to fall on the floor, knelt down and began punching her on the face, arms, and other parts of her body. Hitting again when she was on the ground, saying, "I'm going to kill you." Picked her up by the hair, off the ground, began dragging her to the front door. He gets her out. He's trying to supposedly get her into the truck. A neighbor is actually seeing it now. He saw, supposedly, Manuel try to drag her into the truck, but then he dragged her back into the house, which she said was probably because he saw the neighbor, so he started dragging her into the house instead of the truck. And then he evidently called her while she was talking to the police and asked her if she was okay, and she said, supposedly, "You almost killed me. What do you mean I'm okay?" So that was July. The neighbor wishing to remain anonymous. So July was pretty scary. You don't have to say anything, sir. But evidently, she didn't have to call the police on him again. And the only thing he just got picked up on was recent when he was supposedly smoking pot and got away. So that's what we have. And the priors include 3 felony, 1 misdemeanor conviction, 1 failure to appear, but that was 2006. 21 unknown dispositions. He's got, some drugs, and some domestic, batteries, a couple at least, violation of injunction. And
Yes.
he definitely likes cannabis and drugs, evidently, allegedly.
Word.
Okay. So I hope you charged him pretty well. Did you know that's a cottage industry, sir? When you keep getting in trouble, you make the lawyers car payments for them? Anyway. I'm not trying to make fun of you. I am trying to make you think, though. Counsel?
Your Honor, state would ask for reasonable bonds on all 4 counts on this case. He is entitled to bond on all 4 counts. None are life offenses or PBL offenses. I would just ask for reasonable bonds, given that he is sitting on an F1, an F2, and 2 F3s. And as you stated yourself, the facts in the affidavit are pretty egregious and pretty scary. There arguably is an independent witness. I understand that this did happen back in July. However, it does not temper down that it did happen back in July, and there's already been PC found for it. And I'd like to point your attention to, you already mentioned his criminal history. He does have at least 2 prior DV incidences, which kind of goes into his state of mind during this incident. So I just ask for a reasonable bond, taking into account that he is sitting on an F1, an F2, and 2 F3s.
And, Your Honor, what I would offer is that Mr. Mustier has lived in the Central Florida area for the last 23 years. He came here as a child. He does own a home here. His family, his mother, his siblings, his cousins, everyone lives here. And that he will appear in court. He has hired counsel. He will appear in court. And I ask for a reasonable bond, yes.
Okay. Well, that's good to know that he's got substantial ties to the community. My first thought was starting at 5,000 on the old case.
Your Honor, I'd also like you to take into account, he does also have a prior VOPs and prior violation of PTR conditions on DV cases, showing an inability to comply with court orders. So I'd ask that you set a bond that is high enough to secure his presence in court, since he's already shown a disposition to not follow court orders in the past.
Do you have any idea about how old the prior violations of probation and failures to obey court orders were? He's 33 now.
I have a VOP in 2016. I have a VOP in 2007. I have a VOP in 2004 on a juvenile case. And then I have a VOP in 2012, as well as a violation of the PTR condition on a DV case in 2012.
Okay, so
The latest being 2016.
The latest is 2016, so we're talking about 5 years. Maybe he might be slowing down a little bit. And it might have been that he's got a drug problem when he gets,
And,
acts crazy.
Your Honor, he did have a 2016 violation, I do believe, and I believe I handled that violation of probation.
Okay,
It probably was that he tested positive for smoking marijuana. He does have the marijuana card, and he did deal with the violation of probation by completing the drug court program here.
okay.
There's some,
All right, well, it seems like it's a little bit less dangerous than it might originally seem, especially if a few months have passed. They are F1s, though. There is at least one. Let's, on the 2020 CF 8473, set the higher bond on count 2, aggravated battery with great bodily harm, 3,500. I understand these other ones are serious, but I'm persuaded by the fact that he has community ties, he's represented, he's coming to court, and time has passed, that we can set subsidiary bonds of 150 on count 1, witness tampering, 2, false imprisonment, 3, battery by strangulation. And in regard to the new case, the trespass on construction site and resisting, 21 CF 5116, I think the $1,000 bond on trespass at construction site and 100 on the resisting, will just stay those as previously set by the judge that saw those. So he's got 2 cases in 2 different divisions. In regard to the alleged witness tampering, ag bat, false imprisonment from July, sir, that would be no contact with the alleged victim, don't return to the scene. If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release. You're not allowed to have any weapons while you're out on bond for domestic. The state's probably going to tell you not to have any drugs, because she says that a lot. And so I repeat the just say no to the drugs terminology, because it seems to be standard out here on these release conditions.
Your Honor, on the 21 CF 5116 trespass on the construction site case, Your Honor, state would ask for a no return to that site as well.
And don't return to that side as well. Okay? All right. Good luck to you, sir.
Thank you.
Oh, yeah. I'm trying to go according to the charges that are now charged on the information.
Okay, so I'm gonna use this order instead, and I'm gonna put that the judge set bonds based on the information.
Okay.
Thank you, Your Honor.
You're welcome. Nice to see you.
So you're reducing this bond, because that charge count 1 on here.
Yeah. Thanks. I put the highest one on the great bodily harm battery.
Okay, thank you.
Am I giving you all this stuff and you're dealing with it? I can put it to the side if you want. All right, now, and here's this. Thank you. Are we back to the normal order?
Yes, Your Honor.
Okay. So is this Mr. Delgado?
Yes, ma'am.
Okay, thank you, sir. All right, so the allegation is case number 2021 CF 5940. It's going to Division 12. We can appoint the public defender to represent you. And this is a warrant case, so that means the police officer swore an affidavit and told the judge, and the judge signed the warrant, alleging that on the 19th of May of this year, that you committed a battery domestic with 2 priors. Now, this is one of those types of charges that can be enhanced to a felony. If you get 2 priors and you come back for a third, it can become a felony. Allegedly, about 4 smacks and about 4 hair pulls, with my notes saying lots of violence and drugs in your background and criminal history.
Your Honor, I would also like to point out in the affidavit, there's an allegation of history between the victim and the defendant. The officer observed a dark color purple bruise and swelling on the victim's left eye. When asked about it, she said the defendant punched her in the eye approximately 4 days ago and did not contact law enforcement. So I'd like you to take into account the history of violence between the victim and the defendant when setting bond.
All right, sir, it's important that we instruct you at this time to have no contact with that person, maintain separate residence. I don't recall in this one if there was a shared residence, but if there was, you'll have a police escort to get some things out of the residence. Okay, yeah. They had been residing together. So if you need a police escort to get some things out of the residence, one will be provided. If you have any guns, knives, or weapons, those are to be put in the care custody of the arresting agency within 24 hours of your arrest. You can't have any weapons while you're out on bond. Now, although it's technically a misdemeanor, it's really a felony because of your priors and your history is creating it being charged as a higher level. And given everything, my original notes indicate a reaction of $2,500 bond on the count one battery with 2 priors, and then count 2 battery domestic at 100. We hope that's enough to keep everything quiet while your case is pending. However, if you violate the no contact order, I think you realize you'll be back here on a no bound status. 2,500. Public defender is appointed. You. Is this Mr. Mobley?
Yes, ma'am.
Thank you, sir. We have
Yes, sir.
a witness present. Ma'am, would you raise your right hand to be sworn in to tell the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, and could you state your name out loud for
Erica
people?
Owens.
Owens, okay, thank you, ma'am. We have a couple of cases, and I'm trying to remember if she's involved in both. One of them is 2021 CF 2277 AO in Division 19, alleging a February 16th
Your Honor, she is the victim in both cases.
all right, walking into the residence and battering her, which is, I think, originally filed as a burg dwelling and domestic battery. And then the 2021 CF 4480, separate alleged incident going to Division 17, alleging aggravated stalking with a credible threat on 17 April, allegedly 4 a.m., banging at the door with the butt of a gun, threatening to kill. They have one child in common. DCF is already involved. Sir, I'm not seeing a public defender application, but you certainly can get a public defender if you want one, and we would recommend that you start out with a public defender, even if you didn't fill out a form. You might want to start out with a public defender and substitute in if you later think you need to get a private attorney.
He has a
I have
private-
a private attorney. She didn't show.
All right, well, sometimes they can't make it early in the morning if they have other court appearances. Which lawyer do you have?
Nicole Benjamin.
All right, well, I won't force you to get a public defender. I just highly recommend
Yes, ma'am.
it, especially if you haven't paid all the different fees, because they charge you per the case, and
She's
it's,
paid.
she's
Is there a notice,
notice of appearance?
yes, Your Honor.
All right, Will,
She said-
okay.
She said she wasn't alerted of the court date this morning.
Well, that can happen because the warrants are outstanding, and she doesn't know when they're going to pick you up. So,
Is there?
but she does know how to handle the situation, sir. Whatever we do here is reviewable downtown with a proper bond hearing, all right?
So I will not be given the bond today.
On one.
Well, let's see what we got. Let's look at the testimony. I did read the sworn statements by the police officers. And I've looked at your criminal history. We'll hear a little testimony. Everything is being recorded, so your lawyer will probably get, either listen to it or get a transcript. And like I said, she knows exactly how to get you back into court in regard to the trial judges on the case also. In the meantime, the public defender is standing next to you as a friend of the court and also trying to make sure you don't say anything that might accidentally incriminate yourself. I think is the real reason she's standing there.
Yes, ma'am.
Okay. All right, ma'am, Ms. Owens, right?
Yes.
Okay, so the state wants to ask you some questions primarily not necessarily to resolve the case or anything, but to see what conditions you need to make sure that you're safe while the cases are going on, okay?
Good morning, Miss Owens. Can you please state your relationship to Mr. Mobley?
I'm his child's mother.
Approximately how long have you known him?
We've known each other for 3 years.
And other than these two incidences, has anything ever happened before?
It's an ongoing situation. From when he went to prison before he violated probation, when he pulled bleach on me,
Okay.
and he went to prison for VOP. And then when he got out of prison, it's still going on. It's not gonna stop.
Ma'am, could you speak up a little bit with the mask and all? I'm having trouble.
I'm sorry, it's an ongoing situation.
Right?
It's not gonna stop.
Not gonna stop.
Has
No.
anything happened since the April 17th date?
His family has been threatening me, saying that if he goes to jail, that they were gonna kill me. I have screen recording for previous court dates, screenshots and everything else.
Okay.
What was the last sentence?
His family's been threatening me.
The family's threatening you also?
Mm-hmm.
Do you want to have contact with Mr. Mobley?
No.
Are you afraid of Mr. Mobley?
Yes.
Do you believe drugs or alcohol have ever played a part in any of these incidences?
No.
Have you filed an injunction?
No, I was just waiting for them to capture him so that I can go forth, because I couldn't go forth to the courts without a actual statement to file an injunction.
Understood. Thank you. That's all I have, Your Honor.
The juvenile court, the public defender might want to ask some questions, but, so, I think I remember, something in one of the police affidavits where you had said that, DCF had taken your child away.
It has got to that situation. They took all 3 of my kids.
Is that because of the threat of violence?
It's just between domestic violence between us.
So because of domestic violence, your kids are in the custody of
For
DCF,
temporary, yes.
which might actually be safer for them if you're getting multiple threats to kill by not just him plus his family. And what are you doing? Have you gone to Harbor House or are you still?
I have went to Harbor House before with my kids, but right now I'm staying at a family member's house because I can't stay at home where I live, because he's popping up when I'm going to work. He's popping up at the house, belligerent, just threatening me. And then his family, they're going Facebook Live, threatening me on Facebook. I screen record, I screenshot everything to keep it docket. So when he has his previous court dates, that they will know that this is an ongoing situation. It's not going to stop.
So even if I lock him up, you're under threat by how many family members are threatening you?
His cousins and his so-called friends.
All right, so if you get to the point where you get a real attorney assigned for the prosecution office, you may want to go ahead and try to show them all of the documents that you've saved as soon as you can.
Right, which I sent it to the state attorney. I emailed it to her yesterday.
Oh, you have a particular lawyer who's involved?
I have a state attorney that I've been in contact with on these cases, and I emailed her yesterday, and I sent her the screenshots and the recordings of them threatening me.
All right, well, it sounds like that you're doing almost everything you can possibly do.
It's not gonna stop. He
All right.
went to prison the first time he violated probation because I was pregnant, and he literally took a gallon of bleach and poured it all over me. And the first time I dropped the charges, and then when he got out of prison, it was the same thing. And he just got out of prison, and it's still an ongoing thing. It's to the point where I lost my kids. He has to take a batterer intervention class for DCF, which he has not done that. And it's getting worse.
I hear you.
May I speak?
Sir, you have the right to remain silent.
Your Honor,
I will tell you that it's being recorded,
Yes, ma'am.
and you really,
May,
Your Honor,
everything about this case makes a judge's hair stand on end, so you probably need to let your lawyer speak for you. Nicole Vanderman knows how to deal with this, okay? You might just need to be patient for a minute, because you're at great risk of accidentally saying something that could be played back at your trial.
no,
Your Honor, I understand the testimony here today. However, as a friend of the court to Mr. Mobley, he is adamantly disputing the allegations that are being stated here today. He actually states that there are other reasons why DCF took the children, other than what's being stated here today. That there are some Baker Acts that the alleged victim has had, and that that is the reason why the children were taken. Apparently, the child was dropped off on his front porch. So it's a lot of back and forth. I'm not sure where the truth is in all of this, Your Honor. And because of the different stories, the he say, she say, Your Honor, I would ask that you take all of that into consideration and set a bond amount. He does not have his attorney here today who knows more about the case, so I just ask that you take all that into consideration and set a reasonable bond.
Your Honor, we did file an information on the 21 CF 2277 case. As the warrant states, the Berg dwelling F2 and a battery DV and M1. In regards to the bond, he is entitled to bond. None of them are life offenses or PBL offenses. However, he does have a very significant history. I have a 2018 AGBAT on a pregnant person, domestic violence, a 2013 ag assault with a firearm, battery on a person over 65, BAT DV, violation of probation, drug offenses, violations of probation, 2018 non-arrest battery DV, a 2016 non-arrest battery DV, a 2016 non-arrest battery DV, 2018 non-arrest or misdemeanor battery DV, a 15 AGBAT with a firearm with a discharge. I could continue to go on, Your Honor.
I looked at the notes, and I also noted, counsel, that he got out of DOC on February 1st, and these calls to the police started on February 16th, so he wasted no time, allegedly. Sir, I can't tell you over and over and over again, I guess it won't matter, but the truth is, Nicole Benjamin knows how to deal with this situation. The situation is serious. I've been sworn to practice over 40 years. I've seen a lot. I've seen hundreds of thousands of cases. Every single thing about this case, including your criminal history, makes every hair on the back of my neck stand up.
I understand, Judge, but I'm not trying to disrespect your courtroom or anything.
I don't worry about disrespect.
Yes,
I've been
ma'am.
called all kinds
No.
of stuff, sir. It doesn't bother me at
I will
all.
never do, ma'am, it's because my kids are,
Let me tell you something. There's no way I'm letting you out today.
it's,
I don't care what you say.
so it's basically I'm a life.
No. Basically, I don't know her criminal history, but I've gotten a view at yours. And you you weren't even out of prison for 2 weeks before this stuff started to happen again.
That's why she knows she manipulated.
You need to deal with your lawyer, sir, and let her talk for you. There's too much going on. I'm not taking a chance of getting up in the morning and reading in the newspaper that something happened because I let you out. I'm not the one that's
Yes,
going to
ma'am.
take that chance.
I understand.
You can have a full bond hearing downtown
Yes, ma'am.
with your lawyer, period.
Yes, ma'am.
Your Honor, I believe he's entitled to a bond on all of these charges.
I don't believe under the law, Your Honor, you can hold him no bond on the aggravated stalking with a credible threat or the BAT DV that came in no bond, unless there's a pretrial detention motion.
No, I could set a high bond.
Yes, Your Honor.
Excuse me, can I say something?
I just want him to calm down because there's way too much going on here. And he's got plenty of opportunity to talk to the judge downtown.
And most of those charges that the state attorney read were on me. With the aggravated battery with pregnant domestic violence, most of those charges were me.
Yeah, and he's saying that you're like, been Baker acted, and so it's all kind of made up, but he's got criminal history that probably isn't related to you. He's got plenty of criminal history. All right. I don't have anything like an ankle monitor really anymore.
No, Your Honor.
All I got is high bonds to slow them down until, the felony judge puts everything together and tries to figure out what, if anything, could make it safe.
It's not, because he have people stalking my job. I haven't been to work in 3 days because his
yeah.
family members are coming by my job. He will
You
even
better
come by
stay
my job.
out of the way of anybody for the next few days because, now he's gotten arrested and everybody's going to be aggravated over that.
Yeah, they're mad. And they even called me, someone tried to call me last night to pay me to drop the charges, and I wasn't gonna do it.
Well, you're keeping a record of all of that, right?
Yes, ma'am.
All right, because he's evidently not the only one that you have reason to be afraid of right now. So document it all, give it to the prosecutor, and hopefully they will help in regard to that as well. So state, which charges were filed on which case number now?
We filed an information on the 21 CF 2277 case. What is shown in the warrant, we filed the same thing, the Berg dwelling and a battery DV.
All right. So let's set 5,000 on the Berg dwelling, 100 on the battery DV, no contact with victim, separate residence, no return, any guns, weapons, firearms put in the care of the law enforcement agency within 24 hours of release. And the ag stalking with credible threat, that's not been filed yet, but that's the charge that's currently pending?
Let me double check real quick, Your Honor. I do not believe it's been filed. 4484. No, Your Honor, it has not been filed yet.
So even before I heard her testimony, sir, I was at 20,000, hoping that it'll take you a little while to get bonded out.
Yes, ma'am, I understand, Judge.
So same conditions, no contact, separate residence. Contact means not direct or indirect. That means don't have all your friends and family calling her.
No Facebook, no anything.
Each one of them, if they're calling her and threatening her or attempting to bribe her to drop charges, those are all charges that they can have on them.
Yes, ma'am, I understand.
And she can get protection orders on them too.
Yes, ma'am, so will I be able to do an injunction for myself?
Sure.
Yes,
Y'all
ma'am.
just have everything out in injunction court and file child abuse charges and file animal control charges and,
Yes.
code enforcement and just go at it for the rest of your life. Just fight and fight and fight and fight and
No,
fight and
that's-
fight and fight.
that's
Because
what-
you know what? That's what we deal with every day.
I don't want to live my life like, as you can see, Judge.
Well, you know what? It takes two to tango and it takes only one to drop the gauntlet and go walk away and never come back. So, maybe that would be something to consider.
Your Honor, state would also ask for the condition that he's not allowed within 100 or 500 feet of the victim's residence or place of work.
Or place of work. Ma'am, I don't know, I can't be around there with a gun helping you be protected all the time, but this is what I can do right now. And I think you're doing everything you possibly can, and I wish you good luck.
Okay, thank you.
You're welcome.
Yep.
Follow DCF orders. Oh, okay. All right, is this Mr. Townsend?
Yes, ma'am.
Thank you, sir. We have case number 21CF6123, Division 22, and we can appoint the public defender to represent Mr. Townsend. We have a witness, ma'am. Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. And I'll ask you your name for the record. The state usually likes to ask the questions about safety while the case is going on. What is your full name, ma'am?
Lanisha McFarland.
Okay.
May I inquire, Your Honor?
Yes, ma'am.
Good morning, Ms. McFarland. Can you please state your relationship to Mr. Townsend?
Girlfriend.
Could you speak up a little bit? I've got a printer going in my ear and
Girlfriend.
Thank you.
And approximately how long have you known him?
Like between 8 and 10 years.
Okay. And has anything like this ever happened before?
No,
Are you afraid of Mr. Townsend?
no,
Do you want to have contact with him?
no,
And do you believe drugs or alcohol played a part in this incident?
no,
And if anything like this ever occurred in the future, would you feel comfortable calling 911?
yes.
All right, thank you. That's all I have, Your Honor.
I didn't hear the answer to the question, do you want contact?
She said no, Your Honor.
Okay. Is there anything else you want to say?
No, ma'am.
Okay. All right, then. The allegation was domestic battery by strangulation. And I guess the defense is satisfied that we've asked enough questions.
Yes, Your Honor.
Anything by anybody? I've got a number and I anticipate the conditions requested, but if you want to say anything, that's okay. I understand that there's two different points of view that were told to the police officers. But she's the one who had injuries. And the allegations were concerning. I'm willing to find probable cause for the domestic battery by strangulation. Order no contact, separate residence. You can have a police escort to get some things out of the residence so that you can abide by the no contact order pending any further court hearings. If you have any guns, knives, or weapons, put those in the care custody of the arresting agency within 24 hours of your release. She says she's not afraid, so let's say $2,500 bond on the battery by strangulation. I was concerned about the allegations. And I think possibly the state's going to ask for no non-prescription medications or drugs while you're out on bond because, number one, it's a standard that she tends to ask for, but number two, she absolutely asks for it when it seems like it might be relevant to the situation and/or there's a history. And so we'll order that also. Hopefully that's enough to keep everything safe while the case is going on.
I have a question. You said case still going on. I'm moving to Texas in a couple of weeks.
Could you say something a little louder?
I'm moving to Texas in a couple of weeks. So when you say ongoing, am I gonna have to come back down here?
Well, let me put it this way. If you don't come back, the charge will eventually be dropped, because that's just what happens.
Okay.
So, and you may or may not be concerned about it if you just leave. I don't know that I'm seeing a whole lot of history of him doing this before, other than a lot of drug history. But if you do come back and the thing, presents itself to me, the domestics are, if the witness is willing to prosecute, then we end up putting him on probation and making him go through a 6-month course called domestic or batterer's intervention, which is about 50% effective in preventing it from going on in his future relationships. So you can be somewhat determinative about whether he gets that opportunity. Felony probation's no picnic, especially if someone is used to doing drugs, they might not be able to make probation. But on the other hand, you might give him an opportunity to get at least a 50% shot that he won't do this to any future girlfriend. So I'll leave that up to you. I don't think the state's going to get on a plane and haul you back here.
Okay.
But, you know, they can't prove the case without you either. So that's all I'm going to say.
Okay, thank you.
You're welcome. Okay. I think Mr. Blanc is going to need an interpreter at 1 o'clock, right?
Yes.
Okay. Is this Mr. Coleman?
Yes, ma'am.
All right, thank you, sir. This is case number 21MM3572, and we can appoint the public defender to represent Mr. Coleman. We have a witness here, ma'am. Could you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, and I just need you to speak up a little bit because I'm having a hard time hearing through the masks and over the printer.
Your Honor, may I inquire?
Yes, ma'am.
Good morning. Can you please state your name for the record?
Selena Diaz,
And what is your relationship to Mr. Coleman?
his girlfriend,
Okay. And approximately how long have you known him?
4 years.
And has anything like this ever happened before?
No.
If anything like this ever happened in the future, would you feel comfortable calling 911?
Yes.
Are you afraid of Mr. Coleman?
No.
Do you want to have contact with him?
Yes.
And do you believe drugs or alcohol played a part in this incident?
No.
All right, thank you. That's all I have, Your Honor.
Okay, I'm trying to remember this one. I've got the notes. Bruises to the arm, the elbow, the shoulder, and all over the back. Previous domestic violence not reported. A neighbor called police, I think, if I'm remembering correctly, because of the noise or the screaming, I can't remember. And he denied it, but he didn't have any injuries, and she did. They're exes, but they still live together, and he was worried about photos on your phone. And I wasn't sure if one of the photos showed another guy in your bed, but evidently, allegedly, he freaked out over that.
Your Honor.
And so you still want contact?
Yes.
If you have another boyfriend, that's a seriously provocative situation.
I don't have another boyfriend. I'm not talking to anybody.
Your Honor,
And you still want to live together?
Currently, yes. Until our lease is up.
When's that?
This doesn't happen often with him. I don't feel afraid of him, and we do have a child together. We have a lot of history. I still care about him. I don't feel threatened to the point of pressing charges.
Yeah, bruises all over the place, and you're okay with that?
I'm not okay with that, no, but I don't feel threatened in any other way from here, this point out.
So you're okay occasionally getting bruises?
It's not so much occasional. It doesn't happen often. It's not a repeated thing. That's why I don't feel so threatened. Like
It doesn't
know that
happen
after
very
this-
often, it just happens every once in a while.
Your Honor,
I'm just trying to get to the bottom line. And you're okay with however often it's happening, is what you basically, I mean, if you're willing to go back, you're basically okay with it.
Yes, then I guess I'm okay with it.
All right, let's just be clear about that. You're willing to take the risk, okay?
Your Honor, he does qualify for pretrial release. I would just ask for pretrial release. He lives here in Orlando, employed full-time. So I would just ask that you place him on pretrial release.
All right, well, ma'am, like I said about the prior lady before you, if you don't show up to court, it's pretty hard for them to prove it, although they might have some pictures of all the bruises. And sometimes a jury will find them guilty even if you don't show up. And if you do show up, they'll put them on probation, which is a big fat hassle. But they also make them go through a 6-month course, which is about 50% effective, which is better than nothing. I'll just tell you that for the future reference. Because they don't automatically grow out of it, you know? I'm a lot older than you, and I can tell you something. All those things you tell yourself about how the man's going to grow up, it's wishful thinking a lot of the time. They don't always grow up, and they don't always grow out of it, and there's nothing magical about that, okay? So if you have to make them go through this stupid 6-month course, you know, and you got a child in common, maybe that might be worth it. Just saying. He doesn't have a horrible history. State, you're going to argue against the PTR? I'll tell you,
No, Your Honor, he only has the one
prior,
juvenile, that one charge. I believe it was ultimately 13 charges, but that one incident.
all right,
The
well,
state has no objection to PTR.
okay. All right, PTR, no hostile contact. Even if she's got pictures of other men on her phone. Follow all your court dates. If you have any guns, knives, or weapons, put those in the care custody of the police office that arrested you within 24 hours of your release. Anything else?
No, Your Honor.
That's it for now. Good luck to you. Is this Ms. McCormick?
Yes.
Okay, ma'am, thank you.
We do have a witness approaching, Your Honor.
Okay, thank you. We have case number 2021MM3549, and we can appoint the public defender to represent Ms. McCormick. All right, sir, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you, sir.
Your Honor, may I inquire?
Yeah, she, doesn't have much history, so, but the state's gonna ask you in regard to safety considerations.
Good morning, sir. Can you please state your name for the record?
Michael McCormick.
And what is your relationship to Miss McCormick?
I'm her husband.
Okay. And has anything like this ever happened before?
There's, yes,
Okay. Approximately how long ago would you say the last time was?
years.
Okay. Are you afraid of her?
No.
Do you want to have contact with her?
Yes.
Are you willing to call 911 if anything, if she ever threatened you in the future?
Yeah,
Okay. And do you believe drugs or alcohol played a part in this incident?
they did.
Would
That's
that
not,
be the
that's not
Xanax
normal,
that is said in the report?
yes, it's in the report, yeah.
Okay. I believe she qualifies for PTR, meaning that she could be released without paying a monetary bond. Is that something that is okay with you? Okay, thank you.
Yep.
That's all I have, Your Honor.
Okay.
No questions, Your Honor.
She's going to ask for no non-prescribed medications while the wife is out on bond. Is that a problem?
I'm sorry?
State's generally going to ask her not to take any medications that are not prescribed to her while she's out on bond. Is that a problem for either one of you?
I am probably gonna insist she's actually start seeing a doctor. Is that gonna be an issue?
Oh, okay, so like say if she needs Xanax, you're going to insist that she go check and see if she needs it and if it gets
I want to see, I
prescribed.
want a doctor to decide.
So the only order would be that she doesn't take medication unless it's prescribed.
That's it, man. Thank you. All right,
Okay.
I just want to understand that.
We're all set with that. Okay, so I think we're at pretrial release because she doesn't have enough history to qualify to have to pay a bond to get out. But no fighting and no hostile contact while the case is going on, okay, ma'am? And no medications unless they've been prescribed, so, go through the doctor and figure out what amount is appropriate, I can't even imagine taking 2 Xanax. because I got it prescribed once for some surgery, and I took one, and I was about on the floor with that. So that must have been a wild ride. Okay, and if you have any guns, knives, or weapons, those generally have to be put in the care custody of the police office that arrested you for safekeeping while the case is pending, and give that to them within 24 hours.
Nothing.
Anything else?
No, Your Honor.
Mercifully, this was not anywhere near as concerning as some of the other cases we've had today. Thank you.
Thank you.
Good luck.
So, I'm sorry, she'll be released?
Yeah,
currently?
I don't know how long it takes, but they've already probably pre-processed some of it. They'll tell you downstairs. All right. Is this Mr. Previllon? Okay. Sir, I think I just saw you last week. No, maybe, let's appoint the public defender first before you say anything, because you might accidentally say something that could be played back at your trial. The new charge is alleged violation of, what is it? The new charge is violation of a no contact order, I think, the one that we
Yes, Your Honor.
put last week. And the new case number is 21MM3577, public defender appointed. It was alleged that he was outside and also texting after the no contact order. So, let's set bond.
Your Honor,
Yeah,
they would argue for no bond. He did violate this court's order. He does have a kind of concerning history regarding what he's been arrested for. The underlying battery DV, ag assault with a firearm. I don't know if you re-looked up the facts in that case or.
I did. I looked at it again.
Pretty concerning. It alleges that he slapped the defendant in the face, and while on the ground, he took out a firearm, pointed at her feet, demanding for her to give him his phone, threatened to shoot her if she didn't comply, took her cell phone and broke it with the end of the gun. When she attempted to get away, he pulled her back, put his hands around her neck and choked her.
Yeah, it was very concerning. And last week, I let him out on a $10,000 bond, and he's back.
Your Honor, and again, Your Honor, I would ask that you set a bond amount in this case. I didn't see anything to where the state filed that would hold him at no bond. I mean, I would just ask that you double the bond amount that you issued last week. I don't see any convictions based off of the face sheet that I'm looking at, Your Honor.
Prior convictions, you mean?
Yes, Your Honor. I don't see any prior convictions. My client is employed part-time. He's lived here for over a year, and disputing all the allegations that were just stated, Your Honor. So I would just ask that you, if you are inclined to set a bond, you would double it.
Your Honor, there's also been several threats to kill.
Yeah.
And then violating the no contact order, say he has a concern regarding the public safety as well as the victim's safety. And for the victim's daughter.
I'm concerned about the other case.
Your Honor, if you're inclined to grant bond on this case, they would ask that you revoke him on his out on bond case.
That's what I was originally planning to do, because this one is being filed as a misdemeanor. And I was originally thinking 1,500 was actually a number that I was comfortable with a bunch of years on these violation of no contact orders, to let them know it's, even if it's a misdemeanor, it's a significant one. But in regard to 2021 CF 5514, sir, I think that the relatively immediate violation of the no contact order plus repeated texting and being outside her residence, it does violate the release conditions. And it's appropriate, I think, to just revoke the bond on that at this time. When it comes to guns, you know, and there's like two guys out here threatening their girlfriends with death threats while armed with a gun, there's no way I can take a chance on that. Why would I possibly take a chance on you making good on those threats? And you need to be careful because you don't want to say anything that could be played back at your trial. But there's no reason why I should take a chance on that. Let me tell you, there was one time in the 22 years that I was a judge that I let a guy out and he actually went out and killed the woman. And I can't even tell you how deep the responsibility is when I woke up and read that in the newspaper, that I had let him out. There's just, you can go back to the other Judge LeBlanc and ask him to let you out, but my reaction is, you didn't even go a week before you went back and you kept bothering her.
Your Honor, just to be clear, what was the bond amount for the violation? You said 1,500?
Yes, ma'am.
And then,
No bond on the one that he's out on bond for. You need to abide by court orders, sir. Period. End of story.
Your Honor, I know it's kind of redundant, but in the violation case, they would also ask for no contact and a no return.
Okay, so ordered. When you start abiding by court orders, then life will get simpler. Sir. You're welcome. It's been an intense morning already. All right, is this Mr. Borque? No, oh, we already dealt with that one, oh, sorry. Is this Mr. Loria?
Yes, ma'am.
Okay, thank you, sir. This is case number 2021 CT 3152. I'm sorry, yes. And I think it's a failure to appear on a no motor vehicle registration case.
Yes, Your Honor, state conveyed an offer of an adjudication, credit time served.
And the bond is 500 if you'd rather, bond up, clear out your registration and see if you can't get it dismissed. And he was out on a fling and attempting to elude, but I didn't look it up, but my guess was it might have been in a related charge at the similar date. He got different court dates for the misdemeanor and the felony and, gets mixed up or easily that way.
Your Honor, he would like to accept the state's offer of an adjudication of guilt, credit time served.
Was it related to the felony?
That Dwillis and fleeing.
I couldn't see.
Occurred on 4/26. This case occurred.
Thank you for looking that up.
No motor vehicle registration occurred on 4/28. I do believe it all. No, I think it's something different.
Same.
So that's what I'm concerned about, if he pleads out and it's related.
It's different, Your Honor, I believe.
Well, sometimes what will happen is,
Separated.
they file the misdemeanor 2 days later because they finally turn in their paperwork.
Your Honor, I believe he picked up the fleeing and attempting to elude in a Dwillis, that case. That was 4/26. He also had a no motorcycle license case from 4/26. And then he picked up this no motor vehicle registration. It says 4/28.
Kind of hard to tell if it's related or not.
It's very close in date, so I don't know if there was something, it's skewed in the system. So it may be related, but it doesn't look immediately related.
So to be safe, Your Honor, I will wait to resolve that case.
was that originally just a citation?
Yes, Your Honor.
Let me look at his criminal history a little bit, because I'm thinking see, what happens is you get more than one thing at one time, and especially if they filed this registration later, it's real easy to mix up your court dates. You could end up with 2 misdemeanor court dates in traffic court, and then your felony cases also. It does appear that you've run away from some things in regard to the driver's license, and obviously you're paying the price now because you got driving with license suspended, you got fleeing, attempting to loot. So now you're at the point every time you see a copy, but you feel like you got to leave, and so you're running like a scared rabbit because I'm just saying, that's what happens. You get your license messed up, and now you're scared. So now you're in felony court. But I'm tempted to say this registration might have been appended, and it's understandable that you're getting mixed up with your court dates. And I'm tempted to let you back out on that,
Thank you, Your Honor.
assuming that getting picked up on it because you got so many that you're getting confused is enough to give you the inspiration to try to keep track of them. Now, and we'll appoint the public defender. Sir, do you have access to internet?
Net, yes, yes.
Okay. You can look up all your court dates and try to keep track of them.
Can I speak, ma'am? 'Cause I called-
Your Honor, so are you trying to ROR him?
Well, I'm thinking
He
about it.
has 3 failures to appear, notwithstanding this last one. State would ask that you stay the bond is what it said as. I believe it's reasonable given. What is it?
It is reasonable.
500.
It is reasonable. I understand that.
Notwithstanding this last failure to appear, he does have 2 priors, and a rather short criminal history, therefore he probably failed to appear on not many cases.
Your Honor.
So I would just ask that you stay it. It is a low bond that I believe you'd be able to make.
Your Honor, my client, he cannot afford a bond right now. He states he's unemployed. If you look, majority of his convictions are all nonviolent offenses. And there is a mix-up. I don't want him to explain it to the court, Your Honor, because I do not want him to admit anything as everything is being recorded. So I just ask that you do consider RORing him on the no motor vehicle registration.
Well, I used to try to help people get their licenses back, and I recommend to you, sir, that you can go to the driver's license department, you go to the clerk's office and find out what all these requirements are that you failed to pay. And you tried to pay some of them. You've tried to pay on some, so you need to start picking through them. I understand the state's recommendation is completely reasonable, but I'm just giving you the benefit of the doubt, notwithstanding the fact that you failed to deal with your license and you failed to show up in court before. Obviously, I'm going to let you out, but they're going to give you another court date. Now you've got a court date on your no valid registration. You may or may not have a separate one on the driving with license suspended and a separate one on the fleeing and attempting to elude. I'm going to advise you to try to keep up with it on the clerk's website under clerk's records and look up your name. And you probably find a lot of stuff there because there's a lot of tickets and cases that you still need to pay. But as far as your court dates, if you can keep those straight, maybe you can avoid coming back to court, start picking off your license situations. You're fixing to get yourself put in a 5-year revocation if you don't pay them off. Yeah, not to mention having to flee like a scared rabbit every time you see a cop, which is ridiculous.
And no action on the auto bond?
I'm not taking any action because I'm thinking it's the same pile of dog doo-doo that he stepped in. Now, more than once.
Yes, Your Honor. He understands. Thank you, Your Honor.
Good luck.
Thank you, ma'am.
If you need us, I'll be back again. Okay? Okay, is this Miss Talent?
Yes, Talent.
Thank you, ma'am. All right, we have 21CT3816 in Division 82. and she might be out on bond for something. Let's appoint the public defender. The new one is a DUI. They had enough information to file it. Even though it wasn't a breath result, they took a urine sample that will be pending.
I've done 3.
They had enough information to file the charge. Bond on that's 500. And,
State would request no drugs or alcohol without a valid prescription.
okay, ma'am, what she's asking for, and she usually asks for, is that, while you're on a bond for the DUI, that you don't take any drugs that you don't have a prescription for.
I don't take drugs.
All right. And did we have was it a separate case number, I guess, on a resisting?
Yes, Your Honor.
21MM3570. And I was willing to set amount of 100 on that, because if it had been on the same police report, it would have been a secondary case. And that is going to Division 80. Ma'am, when you first get out, the way things are set up when you first get out is you might have a different court date on the resisting than you have for the DUI, because for some reason we don't put those together at first. It has to do with just randomly assigning case numbers in court divisions, and your lawyer has to file a motion to get them put back into the same court. So if you get 2 different arraignment dates, be careful about that, and make sure you can come to both of them, and hopefully your public defender helps you in regard to that. You know, she was out on bond on a trespass and a resisting and a bat Leo.
Your Honor, she was out on bond. I believe she just bonded on that. Well, she just picked it up May 11th, so
There's no information.
15 days ago. And it was explained during court that she cannot pick up another new law offense. I would ask that you revoke and double. It was 15 days ago.
All right, I have the 1,200 total, but I didn't have the breakdown on my
It
paperwork.
was 100 on the trespass, 1,000 on the bat Leo, and 100 on the resisting without. I would just point to, in that case, she had a bat Leo and a resisting without. In this case, she also proved to be a little difficult for the officers, just showing an overall pattern of behavior. So I would ask that you revoke and double.
And I would just argue there's no information filed in this case, Your Honor. So I'll just ask that you take that into consideration. She seems to be unemployed at this time.
Your Honor, it was 15
Well, the only
days.
reason there's no information is she didn't even wait until it was long enough to file one.
Yes, Your Honor.
You know, and that's actually more of a sign that she's getting into her problems more deeply. But she does have a public defender on that. Ma'am, 55, and you don't have much of a criminal hit. You don't have much, and so something is happening in your life. I'm sorry about that. But when you get out on bond, you're not supposed to get any new charges. And now, a lot of judges would just no bond you and not care about it. You know, what I'll do is I'll double it. So I think the state read out the charges in order. I'm not sure, but
Count 1 was the trespass, Your Honor. It was 100. so you're
100,
gonna
we'll
set
make
it
that
to-
200. Count 2
Was 1,000.
was 1,000, we'll make it 2,000. Count 3 was 100, we'll make it 200. So we'll double that bond and hope that it impresses upon you the importance of obeying the common release conditions, which are that you get no new law violations.
Okay.
So you now have 3 cases pending, because we split the misdemeanor in 2. And so be careful about your different court dates. If you start getting mixed up, then look on the clerk's website under records, under your name, and you can keep up with the paperwork in regard to the court dates. In addition, your bondsman will help you with that, I think.
This is.
And you've got public defenders, so try to get in touch with them.
Bond, and then the bond on this.
Now might be a really good time to go to Alcoholics Anonymous or get some counseling really fast, because not only does it help calm you down while the cases are pending, but it gives you something to show the judge about how you're taking it seriously when it comes to figuring out what has to happen in regard to the case.
I've been a member of AA for 8 years.
Okay, well, might be a good time to go back. Good luck, ma'am.
So this is the true amount of the bond, so, okay.
All right, is this Mr. De Jesus de los Santos?
Bond it, Your Honor.
Oh, no, that's right, you had it tabbed on there. Okay. All right, so we're at Mr. Barnett then, right? Is that you?
Yes, ma'am.
Thank you. So this is case number 2020-MM7684. It's an alleged failure to appear on a failure to report death case, and we can appoint the public defender to represent you. The bond on that is $1,000.
There's no offer at this time, Your Honor. The state would just ask that you stay that bond.
Okay, and it's indicated that's an add-on, so maybe it's just an additional thing in regard to some other things that you have pending. All right, so appoint the public defender,
He has a private attorney, Your Honor.
private attorney, one more case to deal with. That's it for now. Is this Mr. Brandon Pritchard?
Yes, ma'am.
Okay, sir. We have case number 2019 CT 6390, and it's in Division 62. We can appoint the public defender to represent you. It's an alleged violation of probation on a DUI, alleging that you violated probation in several respects, including getting a trespass in an occupied dwelling charge on April 20th, not making all of your reports May through September, not having enrolled in the DUI school on time, and/or telling them that you did when you might have not done it yet or something, and/or completing community service hours and DUI school and victims awareness and vehicle impoundment. So at the moment, it's at no bond, it's in Division 81. That's not really uncommon for VOP, sir, but we'll appoint the public defender. And I think you're supposed to get over to the VOP court fairly quickly.
Okay.
All right? Good luck.
All of those, the charges I had for Marion County in April, they were all dismissed when I got arrested for over there. All the charges were dropped.
Okay, they should have that on all their information when they get to the VOP court.
Okay, so I gotta wait to VOP court?
Yeah,
Okay, thank you.
you're welcome. Okay. We're doing the ordinances before the felony VOPs, okay. So is this Mr. Sprague? All right, sir. We have a new case of 21MO616 in Division 84. I'm not saying a public defender form, but I'm sure you would qualify. And it's alleged, what they call disorderly, but it's, I think, really panhandling.
Yes, Your Honor. State has conveyed an offer of a withhold and credit time served on behalf of the city.
And, Your Honor, I did speak to him, and he does understand the rights he will be giving up, and he would like to accept the state's offer here today.
Okay,
And because he's accepting the state's offer, I would just ask that you take no action on his out on bond.
is that okay with the state?
Yes, Your Honor.
All right. All right, sir, so we won't violate you on the possession of fentanyl, and we'll just get the new one finished, if that's what you want to do. right, would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? Thank you. Thank you very much. You can put your hand down, sir. Thank you. So have you seen this form before?
Yes,
Okay. And you know that you're giving up, when you plead no contest, you're giving up the right to have a trial, the right to have a defense, the right to have your lawyer check your case for technical defects in the state's evidence and to advocate on your behalf, and the right to see if the state could prove it or not before a jury of 6 people, all of whom would have to be convinced that the state proved it. You understand all that? Willing to give up those rights in order to finish your case today? And if you were on probation for anything, this would violate probation. If you're not an American citizen, this could result in deportation. Understood? Okay. It appears that you are alert, intelligent, evidently sober, and entering this plea in a free and voluntary practical manner just to get it over with a withholding credit for time served. And there's a factual basis. I'll accept your plea, withhold adjudication on the charge of disorderly conduct, and send you the credit for, I think, 2 days' time served.
Yes, Your Honor.
Release yes to this charge. We always impose the court costs, which are a little bit over $300, I think, at this point, but we give you a year to pay in case you're trying to clear up your driver's license, because we suspend your license whenever you don't pay. And we'll take no action on the case on which you're out on bond. That is 2020 CF 13573, because you've resolved the new case, and that's practical. Good luck to you, sir. Okay. Mr. Vaughn's case is 21 CO671, Division 62. It's a soliciting. They've got enough information to file the charge. Let's appoint public defender.
Tomorrow?
Yeah, can we try and reset it tomorrow to see if he would like to resolve the case, Your Honor? There is an offer.
Oh, I don't mind.
Okay, thank you, Your Honor.
Is clerk okay with resending it for tomorrow?
Yes.
Okay. Just remind me when we come back what the offer is. Okay. Sometimes it takes them that long to wake up. Is this Mr. Noto Barolo?
Yes, ma'am.
Thank you, sir. We have a case, more than one maybe?
I believe it's just one violation.
Okay, one, I'm sorry. A 2020 CF 1684, that's just one, I'm sorry, sir.
Okay.
It was a violation of probation on what originally was a simple battery, but with priors it became, I think, a felony. And it's alleged that you violated probation by failing to report in December and November, and moving, and they didn't know where you were, and therefore you didn't complete the batter's intervention program.
Yeah, I moved into the Salvation Army. I tried to get on my feet. I was homeless. I went to the coalition.
I don't want you to accidentally convict yourself, but
All right.
we understand what you're saying. We're still gonna let you go see the probation violation judge, and they'll tell you, what you're facing over there, and you'll see them, I think, within about a week or 10 days or something.
Your Honor, you're,
Another hearing from in jail here?
Well, they used, I'm a substitute judge, so I think they used to have a judge here. At least it's going to be it might be virtual, but you're going to have a fairly quick hearing on that. And we're appointing the public defender.
you held that no bond, correct, Your Honor?
Yeah, it's no bond on the VOP. Did I skip one? You want to recall it?
No, I don't remember calling it.
No, are you thinking I remember the name?
Madam Clerk, who do you have?
She's asking me about Arguello. Did we skip somebody on a failure to appear on a fleeing attempting to elude?
It's not on your list? No? Okay, I'll put them to the side.
I don't have.
Okay, maybe we'll call him later. All right, is this Mr. Smith?
Yes, ma'am.
Okay, sir. I think we have a violation of probation on case number 2019 CF 2420. will appoint the public defender to represent you. It's in Division 19. It was originally battery by strangulation and domestic battery. Probation officer alleges that you didn't finish the batter's intervention program by April 16th.
I just got out, March 9th. I haven't had time to even.
Don't talk about the facts.
I know, I'm just telling you, I just got out March, and I haven't had time.
All right, so, well, that's something that you probably have to talk to the judge about, because it could be failure to enroll and complete is the way they state it. So there might have been, actually, the sentence date was supposedly 2019. And I don't know if you were in on this or something else, but if you were unable to complete because you were in on something else, then the other question becomes, was the something else, when did that happen? But I don't really touch the VOP bonds. You need to go to see that particular judge. I am appointing the public defender, and you'll see that judge pretty quickly on that.
Just I had, she's gone now. He's gone now, so.
Well, what they'll do is they'll see everything in the file, and, you know,
I
these,
think this was a big mistake on my attorneys, my PO said this was a big mistake. She don't see how I'm violating and I just got out. I just got out and how I'm back in here on a VOP.
your probation officer said that?
Yeah, she said she didn't recommend me get violated. She said she don't see how I'm in
It
here.
looks like he just got released from DOC on 5/22.
Okay.
But I just asked that the VOP judge see it, Your Honor.
Yeah, so what they'll do is they'll figure it out, they'll unravel it, probably let you out and put you back on probation. Yeah. Well, you know, they gotta do something, so they,
Because I was working, they came and got me from my job, and like, I was doing the right thing. I don't
Yeah.
think I'm in jail.
well, there are times when we get the timelines mixed up, and, but I feel certain that the judge is gonna see you pretty soon here.
So I can't get a bond today and bond out?
Not today. I think your best opportunity would be, I don't know if the public defender can, like, email the public defender in the felony VOP division and say, you might want to look at this one and try to move it up real fast, because he barely got out of jail and he couldn't have started the batter's intervention program yet.
I'll let the attorneys know, and put in a note so that they can get a hearing set, ASAP.
I believe,
I have time to even get money to get, it's a pandemic, I ain't have time to get money.
Your Honor,
Get in the class, I ain't have time to do anything. I'm
on the underlying case, he did have private counsel.
Yeah, I had a conflict of interest lawyer.
Conflict of interest?
He had Matthew Oshetsky.
Yeah.
Who might take some.
Well, that doesn't mean he'll be right on in on it, but, you know, I think the public defender can probably talk to the PD in the violation probation division and get you before that judge pretty quickly. I don't touch the VOP Judge Bonds, because whenever I do, I get in big trouble. So I'm going to have to depend upon the public defenders to try to move this one up for you. All right?
Yes, ma'am.
Good luck. Is this Mr. Snyder?
Yes, ma'am.
Sir, okay, thank you. We have probation case number 2020 CF 9753. And it's in Division 19. I'm looking for a public defender form. I'm tempted, oh wait, it's another case. To appoint one anyway.
Your Honor, since he's going to be sitting no bond, we request that you appoint a PD.
Right. It might still be here. I've just got too many pages. Yeah, we'll appoint the public defender. He does have a public defender form. And it's alleged that you violated probation on what was a battery charge eventually, by failing to successfully complete or remain in the drug alcohol residential treatment program until they deemed that you didn't need any more treatment. So it's no bond, but, you know, you'll see the judge pretty soon. And you have a public defender. Thanks. Okay, just one out of county, or two out of county warrants? One,
One.
okay. Yeah, the other one might have been a move up, okay. Just, you bought it out? Good for him. So that's it for the morning? Oh, no, one more, oh, no, we got the arraignments. All righty. But let me guess, all the arraignments are in medical? Right.
Every
Is there
single one.
something about being in arraignments that makes you sick? Like yesterday, we had a whole pile, and only one guy was here. Okay, so this is Mr. Anthony Thibault and Larry Watkins. Mr. Thibault, 2021 CT 3568,
Your Honor,
3569.
I'll
Public defenders.
waive and enter a plea of not guilty.
Okay. It's got 10 days in so far.
Both cases are Division 80, pretrial conference, June 25th at 9:30, courtroom 9C.
Okay, and the other one is Larry Watkins, 21 CT, not 494 AE. It's no valid.
Yes, I will waive and enter a plea of not guilty, Your Honor.
Okay,
Division 82, pretrial conference, July 12th at 10:30, courtroom 10B.
all right, and then we have the 33-day motions.
Yes, Your Honor, I'm ready whenever you are.
Okay,
Marquise Henderson, 21 CF 883, notice and on filing.
okay, motion is granted.
Monique Wilson, 21 CF 4615, notice and on filing.
Thank you. Motion is granted.
Marquise Henderson, 21 CF 913, notice and on filing.
Wait, I just got.
Yes, two cases, Your Honor.
Were there three? Okay, we had two for Marquise Henderson.
Yes, Your Honor. The 883 and the 913.
All right, they both were non-filed,
Granted.
right?
Yes.
Okay. Thanks.
Corey Esters.
Wait a
20
minute. I have Monique Wilson first. Do you have that one?
Yes, Your Honor, that was a notice and on filing.
Okay, thank you. Motion granted. All right. Now I'm on Esther's. Thank you.
Corey Esters, 21 CF 4592.
All right, thank you. Going back into session. Mr. Robinson? All right, sir. This is case number 2021 CF 6160. And did you fill out a public defender form? We're still attaching those. Yeah, we normally want you to have a public defender, so we're probably going to appoint one anyway.
Jordan.
Huh.
Yes, he has one. And he qualifies.
You qualify for public defender. The allegation is carrying concealed firearm and possession of oxycodone. Okay. Looks like they have enough information to file those. The bond on the carrying concealed firearm is $1,000 and possession of oxycodone as a secondary charge is $150. Sir, if you,
Your Honor, he does qualify for pretrial release. I would just ask that you place him on pretrial release. My client's a student, looks like he lives in Orlando.
that's amazing because he's got some history.
Yes, Your Honor, they look like trespasses and criminal mischiefs.
And burglary and trespassing the conveyance being like that's what they charge you with when you're in a stolen vehicle and you ought to know better. Yeah, but you weren't driving.
It doesn't matter.
Any objections, State? I'm surprised, but You know, that's evidently what the first appearance information sheet says.
No, Your Honor, he otherwise qualifies. It's a victimless crime, and
Okay,
he was rather forthcoming with the officer.
all right.
No objection.
ETR, public defenders appointed, Division SIP 15.
The state would ask for no drugs or alcohol without a valid prescription and no weapons.
Okay, so ordered.
Thank you, Your Honor.
If you have any guns, knives, or weapons, put those in the care of the arresting officer within 24 hours of your release for safekeeping while the case is going on. Are we trying to pull out Mr. Mead's case?
Welcome.
It's time for the Creole interpreter.
We got to do the Creole interpreter first, Mr. Mead. Okay. All right, am I calling her, or are we doing the other one? Okay,
Yes,
and then
you'll
I'm
hit-
teleconference?
Yes, once it rings.
Okay, thanks.
Rest affidavit, but I can get it.
Okay, I think we're trying to call the interpreter, but while you're talking, what, can you do three things at once? Oh, Arguello? Okay.
Depending on the facts of the case.
Okay, so I guess we're dealing with Arguello before we get the interpreter on the phone. And I do have notes, so I can work from them. We got so much paperwork, we don't even know where the files are. All right. Arguello has three things. She's got 21 CF 6058, a failure to appear in Division 12 on a fleeing and attempting to elude. We'll appoint the public defender if that hasn't already been done.
I'll waive the appearance, Your Honor.
Okay, bond is 2,000 on that. Second case is 20 CF 6049, Division 19, a failure to appear on possession of controlled substance with intent, possession of heroin with intent. And I think that judge no bonded her on the failure to appear for that. Waive arraignment by the PD, previously appointed, probably. And, oh, she got a private attorney on that?
Yes, on the first two cases, and also on the out-on bond case.
All right, and then I think the new one is 2021 CF 617. It's constructive possession, but there's cocaine, heroin, and cannabis all over the place, so I guess they'll weed that out later about what she should have known about, whether or not she had enough knowledge for constructive possession. The case law used to be that if it's everywhere, then maybe they,
They should have good reason to know it was there.
well, anyway, let's see, the bonds could be on that. Okay, so I think that's Division 11, I think I'll stay the bonds at 1,000 on possession of cocaine and do subsidiaries on the other one, 150 on heroin, 100 on the cannabis, 100 on paraphernalia. And
That case, you're appointing the public defender.
let's appoint the public defender until, you know, if she gets another lawyer, and then there's also an out of bond, which is, she's out on 2020 CF 4186 with a total of 31,000 somehow posted.
Yes, Your
Given
Honor.
everything that's going on, I'm thinking about revoking and letting that either private attorney or combination of private and PDs figure out what to do with 4 cases pending at one time.
She does have a private attorney on that out-on-bond case.
Does?
Yes.
Looks like a PD named Bano.
No, he's a private attorney, Your Honor.
Oh, okay. I don't know
Are-
everybody anymore.
You revoking and setting it 0?
Yeah, well, they'll figure it out downtown.
Okay.
Do we have the interpreter? Oh, we're waiting. We're trying.
You have to hit the teleconference button.
Thank you.
Okay.
Oh, okay. Is the interpreter there?
Yes, ma'am.
Thank you so much. It's Judge Blackman in Orange County. We have a initial appearance for a Mr. Noel Gwens Blanc.
Yes.
His case number is 2021 MM
Yeah.
3575.
He has
Nous gagnons première comparution pour Nogels Blanc. Cali, c'est 21 MM 3575.
We'll appoint the public defender.
Nous prenons le bon défenseur public qui pour représenter eux.
Okay.
It looks
Okay.
like they can file a domestic battery between two brothers at this time.
Quel que c'est on attaque domestique contre en deux frères.
Now,
Yeah.
my guess is he might qualify for pretrial release, but the pretrial release office didn't get enough information.
Could qualify,
Quel que
Your
vous
Honor.
capable qualifier sorry, vous capable qualifier pour relâche avant procès, mais bureau relâche avant procès pas te recevoir assez d'informations.
Since he can
Ah,
qualify,
bien, non?
since he can qualify, Your Honor, I would ask that he's placed on pretrial release.
Is that what you said? I could not hear.
Yes.
Okay, sure,
Your Honor, state has no objection. The battery wasn't incredibly egregious,
right.
and we don't have victim input here today, so state has no objection.
Right, then, sir,
OK, pas d'objection de l'État. Donc, monsieur,
you can get out of jail without having to post a financial security.
vous capable sortir de prison sans ou pas besoin mettre on l'agent pour sortir.
Since your brother was not here to testify as to safety today, we'll order no contact for now.
Dit comme frère ou pas t'es là pour lui témoigner à propos de sécurité li. Pour Kounia, nous allons mettre on l'ordre de nos contacts.
I don't think you live together, but if you did, then we would allow a police escort for you to get some things out of the apartment.
Dis-moi pas penser que nous rester ensemble ou pas rester ensemble avec frère, mais si vous t'es resté ensemble avec elle ou bien que vous t'es gain affaire la Kylie, ou capable de retourner en grande fois avec une police pour prendre affaire.
Maintain no contact in separate residence until a judge can hear from both sides to make sure that it's safe.
Ou besoin qu'il y ait une autre résidence, ou besoin de rester en l'autre côté, ou pas capable de rester ensemble avec frère, jusqu'à ce que nous ayons un juge qui est capable de déterminer que bagayo safe pour Kounia, après que les filles n'entendent ni ou même ni frère.
You can keep up with your court dates on the clerk's website under records and look under your name.
Ou capable de connaître qui là ou a gagné une date pour retourner dans le tribunal. Si vous pouvez aller dans le website court là, ou regarder en bas records et vous chercher nom.
In addition to the paperwork that we give you.
En plus de papier que nous prenons bon.
Make sure you come to all your court dates.
Ou besoin sûr que vous venez dans toute date que vous gagnez pour venir dans le tribunal.
Even if your brother does not want to press charges, you still have to come to the court and see how that proceeds.
Même si frère décide que li pas vle poursuivre accusation yo en justice, ou toujours besoin venir dans le tribunal là pour capable répondre juge là.
Your Honor, the state would request the condition of no weapons, firearms, or ammunition.
L'État a demandé pour pas d'armes à feu, pas d'armes et pas de munitions.
If you have any guns, knives, or weapons, put those in the care of the law enforcement agency within 24 hours of your release for safekeeping while the case is pending.
Si ou gagne quelques armes à feu ou bien quelques munitions, ou besoin bayo bay la police pour yo capable kembe bagay yo pour en sécurité pendant que cas ou en suspension.
Good luck to you, sir.
Bonne chance, monsieur.
Thank you. That's all we had, ma'am.
Thank you. Have a good day, Your Honor.
You too. Thank you so much.
Bye-bye.
I believe you've got more. Jeez. Okay. Ms. Benjamin?
Yes, Your Honor.
All right, thank you, ma'am. This is case number 2020 CF 14071. And it was a warrant. Public defender is appointed. It was alleged that back on July 9th that a firearm was reported stolen. The owner of the gun thought that it might have been you who visited, and supposedly there was an Instagram video posted, which you said was at the owner of the gun's apartment, and she denied, and the police officer thought that you'd had the gun after visiting your friend's house. So this warrant was issued back in November in regard to that gun.
Your Honor, she does qualify for pretrial release, so I'll just ask for pretrial release in this case. Looks like she's employed full-time. She's lived here for over a year or longer.
State, I noticed she's got some probation violations as well as some other history. I guess the pretrial release people will tell me if it's wrong, but the paperwork says she qualifies.
Yes, Your Honor, if you're inclined to put her on PTR, state has no objection, but would ask for bond in conjunction with PTR due to the nature of the nature of the offense being with a firearm.
I was concerned about it too.
And the inability to follow court orders. She has, it looks like 2 probation violations, and then she did have an arrest for felony battery where there's great bodily harm. So the state is concerned regarding the public safety if the defendant is in possession of a firearm.
Your Honor, the firearm.
I would see one or the other, bond or the pretrial release, and although I'm surprised that she qualifies, I'll go along with it. There's been a little bit of time in the meantime since the alleged incident. Ma'am, we're a little surprised that you qualify for pretrial release. Don't take it as any minimizing of the circumstances, but let you go out on pretrial release since you qualify. Make sure you come to all your court dates. No contact with a lady who thinks you took her gun. You can't talk to her about her testimony or the case pending or anything. That's a whole nother charge if you do, in addition to violation of release conditions. Just leave her alone. Make your court dates. Talk to your public defender. Good luck.
Your Honor, the state would ask for a no return to the victim's residence as well as no weapons, firearms, or ammunition.
All right, so ordered. If you have any guns or weapons, put those in the care of the law enforcement agency within 24 hours of your release. Don't return to that person's residence. So we're stacking up with private attorneys back here.
Morning.
I don't know, we've got so much paperwork. We had about 45 felonies, so we're trying to weed them out, you know, when the clerk can get them and the lawyers are ready, I'll call them up, okay? Oh, they're pulled out? She's ready?
They're ready.
State ready?
Papers are here.
Is this a different guy or is this one of yours?
It's not like, no.
So let's get him and then we'll get yours, okay?
Thank you.
You're welcome. Oh, is this Mr. Bentley? Okay. I think it's called Warrant Wednesdays where they just pull them all out and serve them all at one time.
Yes.
All right, Mr. Bentley, case number 2021 CF 6156.
Have you filed it in a way?
And
No. Then no.
we can appoint the public defender to represent you. I don't think any of the paperwork came through. There might be a couple of warrants from Sumter, and if we're not dealing with them today, they might come through afterwards.
Your Honor, I would just argue on the possession of methamphetamine. It's only a paragraph in this arrest affidavit, and the only thing that it states is that a search was made of the vehicle and a crystal-like substance was discovered. My client and there was a passenger in the vehicle. We have no idea where the drugs were located, where they were found, if they were near where Mr. Bentley was positioned, where the passenger was positioned. We have no information in regards to that, and I would just argue no PC for the possession of methamphetamine.
I think they did that because he was driving,
Yes, Your Honor, I understand.
and they did field test it. So, well, you're right, there's probably an issue about where it was.
Your Honor, I would just argue constructive possession regardless of where it was in the vehicle. That would be an argument later for a motion to suppress. I think for PC purposes, it's sufficient as he was in the general vicinity of wherever the drugs were located, as they were in the vehicle during and found during a search of the vehicle. I would just argue constructive possession.
Well, not, actually, the Willis, I think, is the larger charge on this one, isn't it?
I believe that's what came in with the higher bond, Your Honor.
Yeah, the driving while license suspended.
Although I will say the officer is not fond of giving us a whole lot of information. It was a very short affidavit. There have been times when I've made him come up with more, just wondering about the practicality of that. Supposedly he's got 8 prior Willis convictions, so I was more interested in that one. So, given all the circumstances, and sir, I think you might have a couple warrants, like I said, that are going to be holding you up a little bit from Sumter, or you might have to go over there anyway. Let's just find PC and point the public defender. Your big one might be the driving while license suspended, count 3 at 2,500. The other 2 are considered subsidiary, grand theft of the motor vehicle, since you're driving an allegedly stolen vehicle, this count 2 at 150. Possession of methamphetamine, well, leave the bond at 150, understanding the lawyers are good, maybe got something to argue about where it was, who had control or not, so they've got something to work with on that one. Going to Division 20, make sure you come back to all your court dates, talk to your public defender if you want them to have a reasonable chance of representing you.
Your Honor, state would request no contact with the victim, witnesses, or any co-defendants, and also no drugs or alcohol without a valid prescription.
All right, those are fairly standard requirements, sir. We'll put those on your paperwork. Good luck. Yes, ma'am. Right. Okay, so I think we just pulled out the private attorney cases, right? And the first one is Mr. Douglas with Mr. Mead.
Okay, it's Mr. Pittman.
Is this Mr., I'm sorry, Mr. which?
Raymond Pittman.
Pittman. Okay, I'm sorry.
Oh.
I'm just looking at the paperwork in whatever order it's in. Okay. Okay. This is case number 2021 CF 4672. Thank you. I didn't get this far down in the stack, to be honest. It is going to Division 14. It was a warrant in regard to an alleged burglar with an assault or battery therein.
Your Honor, we
And-
have since filed an information.
Yeah, I didn't get actually I don't think the affidavit was even printed, so I don't have it in front of me. Have you all worked anything out, or are we going to argue about the terms, and I probably should try to find the affidavit and look at it?
No, Your Honor, I haven't spoken to Mr. Mead. However, it is a punishable by life offense. State would ask that you hold him no bond pending an Arthur hearing. State has already filed an information of the Berg dwelling with an assault or battery therein. I have the affidavit printed.
I would appreciate looking at it, since you're asking for no bond. Thank you so much. Okay, there's a protection order issued on 12/16. Appreciate your giving me a moment, Mr. Mead. So it's October? Okay. Counsel, thank you.
I address the court.
Yes, sir, I'm ready, thank you.
Your Honor, in this particular case, my client, who is 32 years old, 31 years old, sorry, there's a domestic violence injunction that has not been violated, he's had no contact with the victim. My client was living at that address and was in the process of removing his property. And we're asking the court to set a bond. Has no history of failure to appear in court, has ties to the community.
Okay. Well, there's nothing in the report about him still living there, I guess, but I understand that's his position on the matter. So there's still PC for the burglary in regard to the backyard and the fence. The good news is that some time has passed. Also, the injunction, we don't have information that that's been violated. So safety is not a problem right now. He does have some prior domestic issues as well. Not to minimize it, sir, but because of the passage of time, and State really want to say something again?
Your Honor, I would just further put on, it is a PBL, and I ask that you treat it that way. I understand that time has passed. However, he did enter the dwelling and commit a battery therein. I understand you believe that the harm is minimized to the victim due to the passage of time. However, we don't have victim input here today. Regarding her opinion regarding if the passage of time has alleviated the situation and the tension and the stress, and if there's been any more incidences between the victim and the defendant, since we don't have her testimony here today, I would just ask that you treat it as a PBL and hold him no bond.
So I understand the PBL. We've been having this discussion periodically since I've been out here. And, I've said it before and I'll say it again, that I think the PBL circumstances are the ones where somebody's breaking in the middle of the night and scaring the living daylights out of somebody while they're probably, asleep. In this one, it's the backyard fence. And then she went in the house and evidently, that was it after, but he did commit a battery. So, it just, I understand that technically it's a PBL, but I don't know that it's going to really look like that once it gets downtown. It is serious enough. It's an aggravated battery situation in regard to it being broken into the fence and then coming at her. Given all the circumstances, I'm going to set bond at $3,500 on the burglary with a bat. And then there's the secondary charge, I think, of battery with 100. No contact. Don't return to the scene. Any guns, knives, weapons put in the custody of the arresting office within 24 hours of your release.
Your Honor, there's no additional charge, it's just that single charge.
Oh, you just filed the one?
Yes.
Okay, on the Berg dwelling.
Yes.
All right, that's it then, just the $3,500 on the Berg dwelling. Did you want the report back? All right, you've got it, copy of it anyway.
Your Honor,
Oh, you
I would
wanna
take the
put it-
report if they're going to throw it away, since I haven't got a copy yet.
I don't mind if the state doesn't mind.
Your Honor, he hasn't filed it in a way the state cannot give it to him. Or under demand, and it hasn't been filed on.
All right, put it in the file.
So we're putting it as a supplementary report?
That's okay with me. So it's public. Anybody can look it up,
Okay,
all right? She wants it back now because she doesn't want to file then, okay? All right, I guess you'll have to file a notice of discovery.
all right, fair enough, thank you.
All right. It'll be public soon enough, Mr. Pittman. Hopefully you're not proud of that.
See you later.
You're welcome. Thank you. Okay, who's next?
Alicia Adamson, for the record. I am here for Mr. Douglas.
Okay, thank you. Let me find that case here in my, all right. Mark Anthony Douglas. You have that. That was 21 CF 6178 going to Division 15 in regard to some trafficking charges, and also 21 CF 6179 in regard to some other possession charges.
He has a third case.
And 21 CT 3819, Division 83 on a Dwillis. So you've got three things. I'll be honest with you, counsel. I don't really know what the judges downtown do with these trafficking charges and what they ultimately are going to set. And, you know, I prefer to just send them down there and let them do whatever they're going to do. I mean, they're really high bonds, and I'm really shooting in the dark. I don't know what they do with them.
And I've spoken to the state who said that she would leave it to your discretion, wouldn't object to at least setting the second, because he has $200,000 bonds. So if one stays at 100, at least the second being a subsidiary bond, and maybe at 10,000, and we may end up having to file a bond reduction on the one high bond, but the two high bonds are what's almost impossible to get anything done.
Your Honor, that is correct. I did have that conversation with Ms. Adamson. State doesn't have any objection to staying the bonds otherwise, but as account two, lowering it due to it is a very high financial burden.
All right, so you're talking about on 21 CF 6178 for the clerks, staying at 100,000 on possession of fentanyl. I mean, I found probable cause, but.
The trafficking fentanyl?
Trafficking. And then trafficking in heroin, you're talking about 5 figures instead of 6 figures on some of those?
I'm asking for a 10,000 on the trafficking in heroin. So I have 100,000 on one count.
Right, okay.
Yes.
And then you've got all the rest. You want me to just stay them and then you take all that downtown and see what to do with it?
Yes, Judge.
Okay. 10,000 on count 2, trafficking in heroin. 15,000 on count 3, possession of methamphetamine with intent. 15,000 on count 4, possession of cocaine with intent. 15,000 on count 5, possession of alprazolam with intent. 1,000 on possession of cannabis with intent. And count 7, 1,000 on possession of fentanyl. Sir, I'm just letting the judge down there figure out how much. There was another 2 cases. The first one was going to Division 15. The second one is 21 CF 6179. That's going to Division 10. And was that? This, I read a lot of them today. Looks like maybe even the same stop, but they're just continuing with another.
Yeah, I assume that they'll all be put together eventually, but.
Eventually.
Yes. But they are all from the same stop.
Yeah. I guess I can leave them so you can put together. I mean, I understand that they're add-ons, and somewhere along the line, you're going to get to subsidiary bonds. But just to let that judge do it all, we'll find probable cause and leave it at 15,000 on another possession of cocaine with intent to distribute, 150 on methamphetamine with intent, and 150 on possession of alprazolam with intent. That's Division 10. And, sir, yeah. There's a 21 CT 3819, Division 83, drug and license suspended, bond is stayed at 500. They had probable cause, and so, sir, you're probably just going to take it down and get one bond hearing on all of that.
Your Honor, on all of the counts, they would ask for no drugs or alcohol without a valid prescription and no weapons, firearms, or ammunition.
Okay, that's pretty standard, evidently. Okay. Thank you.
Thank you.
Thank you, counsel. Yes, ma'am. Oh, she is pretty cute, isn't she? Yeah, it's a wonderful. Oh, thank you, thank you. Take care, thank you. Nice to see you. Okay, thank you, counsel.
Good afternoon, Judge. Jake Parton for Kenneth Stewart.
Okay, I'm just getting to Mr. Stewart's page here. All right. Thank you for waiting. We're at 2020 CF 13355 CO. And, it was a warrant. It's going to Division 12 Council. Originally, as a burglary of a structure with assault and battery, and petty theft in there. Or is it a capias? I didn't get to the S's in the stack over the lunch hour.
That's okay, you actually have a little bit of guidance on this one, Your Honor.
All right, then, trying to figure out if it's a failure to appear warrant or not, because I don't have any,
It is not, Your Honor. This is the original arrest warrant.
really, is it?
But the cases against co-defendant A and co-defendant B are actually kind of well underway. What's instructive is the original warrant for co-defendant A, who's the alleged instigator and only person who seems to have touched the alleged victim. Bond was set at a total of $1,150. I have the warrant and the bond surety documents for that one. Co-defendant B was picked up, went to IAs, came in with a no bond warrant as well. I think it was Judge Heather Pinder Rodriguez set bond at $2,000 on count one and $500 on at count two. So the two co-defendants were released on bonds of a total of $1,150 and $2,500. There's an additional petty theft M2 count on this case, so I'd be asking bond to be set at $2,000 on count one, $500 on count two, and $100 on count three, which would be the same thing as what was done on the original two cases, and I can approach with that paperwork, Your Honor.
Are you showing the state that?
No, we attempted to exchange paperwork.
Oh, she might have had a lot going on.
I'll look at it. I can give it to the judge. Thank you.
All right. Thanks. Thank you, I appreciate the, I don't have the arrest affidavit, I'm just going off of, so,
I do have the arrest affidavit for the A co-defendant. It doesn't have as much information because at that point, my client hadn't been identified, but it does go over the facts of the Berg bat, which I think is going to be the main concern here.
all right, looks like the same case number, okay. And probably the state might be reading it now if she hasn't already. She gets up and gets down here, and gets the paperwork at 7:30 in the morning and gets started on these, so. She
And if
might-
I can approach, I can at least give you co-defendant A's
Okay.
arrest affidavit.
And I want to be able to give you back, I've already looked at these,
Oh,
thank you so
thank you.
much for that, it's helpful. Okay, I appreciate that. Normally, we get these printed off for the judge, but sometimes we leave one off for whatever reason. It might have been hard to find, it might have been just so many that we lost one.
Hey, we're still doing better in 2020, Judge.
Yeah. I think we're making up for time because I'm doing the work of two judges today.
Definitely.
Okay, second. Okay, oh, maybe she wants me to mark up hers instead of yours. Thanks. Structure, thank you. Okay.
I think there was the added wrinkle of the follow-up investigation with the victim, him saying he has a difficult time recalling the specific facts of the incident and doesn't, I believe, even remember what he put in his sworn statement to police. I actually don't know that there's probable cause for a battery as to my client, but I'm not going to quibble over the M2 at that bond amount.
Okay. All right, State, did you get a chance to read all this and absorb the arguments?
Yes, Your Honor. I did look up Miss Nakaya's Warner's case. I do believe the defense counsel is correct that she did receive a $1,150 bond on the Berg structure with assault battery therein and a battery. I'll just make the argument that it is a PBL. I understand that Your Honor is going to grant a bond on this, definitely given that one of the main co-defendants seemed to be the main person to provoke the incident. I'll just make the argument that there is PC for a Berg dwelling with assault battery therein. The warrant has been signed, and I ask that you find a bond that is congruent with that kind of case. It is an F1. The victim said that Miss Sylvia Warner threw a punch and then the attack occurred with all three. And then they entered a vehicle and left. The victim remembers the victim picking up the gold chain before leaving the business and fleeing the area. I would just ask for a reasonable bond, Your Honor.
Okay. Let's go ahead and find probable cause and set them as suggested by counsel because it's consistent with what everybody else is getting, and I think consistency is it's important for people to understand that we try to be fair. So we'll go with 2,000 on the Berg with a bat, 500 on count two battery, although we'll figure out who did what later, and 100 on the petty theft. It's Division 12, folks. Also, state always asks, no contact with the alleged victim, don't return to the scene. Also, they ask, if you have any guns, knives, or weapons, put those in the care of a arresting agency within 24 hours of your release for safekeeping while the case is going on.
All right, that's acceptable. You understand?
All right?
All right,
Okay,
that's
good
all I
luck.
have, Your Honor. Thank you. Good to see you.
Good to see you, too. Thank you. Okay.
This is your
bottom. I think I'm already cross-eyed. At least a few of them bonded. All righty. Not going back to the original stack. Is this Mr. Brito? Okay. All right, sir, this is case number 2021 CF 5752, and it will appoint the public defender. It was a warrant in regard to an alleged grand theft auto back on May 2nd, supposedly. They suspected the ex-boyfriend of the sister might have stolen the spare key, and due to facts and circumstances and all the circumstances, it was enough to find that it probably was you. The bond amount set by the judge was $2,500 on that. No contact with the alleged victim.
He does qualify for pretrial release. I would ask for pretrial release. He is employed. He's lived here for more than a year. 0 failures to appear. So I would just ask that, based on that, he be given pretrial release in this case.
I am so not used to this. I know things have changed, but, he doesn't have a virginal record. Things are different.
Your Honor, state would ask that you set bond. In the affidavit, it seems more than just a grand theft motor vehicle. What is alleged is that he broke into the safe at the home and stole the key fob from inside the safe. When confronted about it, he fled the scene and said someone else stole it.
Your Honor.
And there was also a tablet within the car. which should have been charged as a petty theft,
Your Honor,
and there's video to corroborate it.
I understand that, Your Honor. However, he does qualify for pre-trial release. There would have to be a reason why he,
What's this other case that they were checking him for OSCO, case number 21-38569, in regard to a suspect in an occupied burglary? Is this the same case, or is it another one? And then they found this warrant. We don't know about that one, right?
no,
So they're checking out some other case, sir. I don't know.
Your Honor, this is, again, I would argue it's a nonviolent offense.
Okay, I don't need to hear it 4 times. I heard it third now, all right? So that's enough. Repetition is not required.
My concern is he has multiple probation violations.
Well, let me go do this. I'll sort of cut the baby in half. The PTR is sticking in my throat, okay? For a couple of reasons. But then 2,500 is a bigger amount than it used to be. Let's just go with 1,500, back to where it used to be, a proportionate maybe amount for supposedly stealing the girlfriend's brother's car with the key fob, where he probably knew where it was in the residence. They have enough information to file the charge, Mr. Brito. That doesn't mean they'll prove it beyond a reasonable doubt. They have enough to file it, and that's the only decision now. So you need to calm down, and maybe, you know, I don't know what this other thing is that they might be investigating. Good luck with that. No contact with alleged victims. Don't return to the residence. Good luck. I hope you slow down. I couldn't stomach pretrial release because of your history, because I'm looking at the juvenile history too. It's just a little too much. Maybe they don't count that, but it's there. Good luck. Is this Darnell Brown?
Yes, ma'am, it is.
Thank you, sir.
Yes, ma'am.
We have 2021 CF 6165 going to Division 17. Sir, we'll appoint the public defender, and they have enough information to file the charge of possession of methamphetamine. The bond is $1,000. After you bond out, make sure you come back to court for all your court dates.
Yes.
The state wants me to tell you to not have any drugs while you're out of bond.
Ma'am? Yes.
Okay, thanks.
Thank you.
All right, Mr. Bullerin, thank you, sir, for waiting.
Good afternoon, Judge.
Good afternoon, sir. This is case number 2020 CF 6787, and it's in Division 15. I think you might already have the public defender, but we'll appoint him if you don't. And I think it's a failure to appear warrant on a criminal mischief over 1,000. It was a trial management conference on January 15th that says revoke release not to be modified by first appearance judge, so I'm going to need for you to talk to that judge. It's no bond right now.
Say something for the record. I was actually incarcerated during court. I don't understand how to appear when I was incarcerated in Volusia County. And the court signed it.
Well, that's something they'll figure out when you get downtown, probably. And it is the unfortunate, inconvenient consequence of what happens when you've got multiple cases going on. It actually causes confusion in the system, keeping up with them all. And if you don't like that kind of confusion, you might want to slow down the activity that seems to be causing these cases to happen. That would be my real advice. Okay? We'll be here if you need us.
I do have a question. Who is the judge on the case?
15? Does anybody know who's 15?
Yes, Judge. It is.
Wooten? Wilson. Oh, Tanya Wilson. She's a very nice lady.
Is there a court date set yet, or?
Sir, would you like fries with that too? Good luck. We have a lot, okay? I'm sorry, but you know. Okay, is this Miss Corbin? All right. You want to handle the refusals in a little while? I'd be okay with that.
Okay, we can come back, Your Honor.
All right, thanks. If you all don't mind. Is this Miss Cornier or George?
Yes, ma'am.
Close enough? Ma'am, the allegation is 2002-1 CF 6108. You might be represented by Attorney Corin Cohen, or he's thinking about it because there's some emails in the file. It's going to Division 17. The public defender might speak for you on behalf of just a friend of the court. No priors, and the face sheet says she qualifies for PTR, but it's alleged aggravated assault with a firearm.
Yes, Your Honor, I would argue for pretrial release. She has no criminal history based on the phase sheet. It does not seem that this is normal behavior, and because of that, I would just ask for straight pretrial release in this case.
Not hearing any objection. Are you still looking at it?
Your Honor, I was rereading over it.
Yeah, it looks like.
My main
you know,
concern is the
Yeah.
proximity of the defendant to the victim.
Yeah, they live next to each other. They have
In like a
adjoining
duplex.
walkways, I think.
I think it's a duplex situation, Your Honor, so I believe there's, I guess, maybe
Something
a shared
close to
wall.
it. Yeah, zero
Um,
lot line, probably.
So my concern is mostly the proximity between the defendant and the victim, Your Honor, that there'll be ongoing issues between the two. So if you are inclined to put on PTR, I'd ask for bond in conjunction with PTR due to there being a firearm involved.
Your Honor, I believe that pretrial release, if she violates, she'll be brought back here. If anything else occurs, she has to turn over that firearm if law enforcement does not already have it. Again, her history does not show anything like that, Your Honor.
All right, ma'am. I always worry about guns, and it's really hard for me to do straight PTR on a gun case, even though, you know, I read a lot of the things in between, and you may or may not have pointed it at them. They might have freaked out. Maybe it didn't happen that way. Maybe it was just like a little reckless, happened to carry the gun towards the door, you know. We worry about these things because we see so many where the gun goes off and people get hurt, you know, and I'm glad that didn't happen. So let's do this. We'll find probable cause for all three. Tell you, no contact now. You live next to them, but because of your lack of criminal history, we're going to take the risk of letting you go back there, but you even have adjoining walkways. So if you see them go into their car at the same time you're going to your car, walk back in for a minute. And hopefully they don't taunt you or anything. I guess they're really loud and that's a hassle. Maybe they'll freak out and move, you know, because now the crazy lady next door, you know, they think pointed a gun. Try to avoid contact, you know, because that is required while you're out on bond. We just want you guys to stay away from each other. And the onus is on you, not them. They don't have that responsibility. Nobody's ordering them to do that, so it's all on you, okay? If you have any more guns, knives, or weapons, put them in the custody of the arresting agency within 24 hours of your release. State's probably going to ask for no alcohol or medication unprescribed because they're a little bit worried about the situation and they ask for that all the time. Let's do PTR plus 1,000 on count 2, reckless display. Just to emphasize the importance of gun charges. It's just really difficult for me not to do anything but PTR on a gun charge. I'm sorry, I've seen too much over the years, and I wish you good luck, ma'am. Yeah, the other ones are just straight PTR.
And Your Honor, the no alcohol or, I don't believe there was alcohol involved in this
I figured she was gonna ask for it anyway, because she, you know, gets, does that a lot, and also because the whole situation is so weird. Like, you're right, she doesn't have any prior record of this,
Because of that, Your Honor, there's no indication of alcohol being involved. I would not ask for no alcohol.
okay, we'll leave the alcohol off, but I'm worried.
Yes, Your Honor, I understand.
So, Your Honor, that's PTR on count 1 and 3 and $1,000 on count 2 plus PTR?
Yeah, thank you. Mr. Crespo. Thank you, sir. We have case number 2021 CF 6078 going to Division 11. It's a warrant from January 21st. Evidently, they had a control buy, and you don't always know about those, and they file them later. We'll appoint the public defender, leave the bond at $7,500 on the sale and delivery of fentanyl and $500 on the sale and delivery of heroin, and take no action on the case that you're out on bond for, 2020 CT 4324, because he bonded on that after this alleged event in question. If you get paid that income weekly, you barely don't qualify for the public defender.
Say it again, ma'am.
Sir, you might be a little bit over the amount to qualify for the public defender as far as your income. Is that your regular income per week?
It depends, because I'm a handyman and I work for a handyman company. Sometimes I make a little bit more, sometimes I make a little bit less. Sometimes I only work like 3 days a week.
Well, let me go ahead and appoint them and see if that works. You might want to check with the private attorney just in case. I understand it would be hard at your income level to get a private attorney, but you might want to try just in case. You might be a little bit over the income level.
Your Honor, state would ask for no drugs without a valid prescription.
All right, no drugs without a valid prescription, sir. Good luck.
When I went to take the paperwork apart, I seen.
You want me to take this out?
No. I seen this note in there. He had a private attorney. So are we gonna refile the case and call the attorney? Usually the judge passes this to us and we make a call, but I didn't realize.
Oh, I didn't know that was the expectation.
Yeah, we don't know until we know. But we can recall it.
It's not getting it.
So we're not recalling it?
No, he'll
Okay.
be fine with that. He'll
So
be fine with
You
that.
want me to take the PD off?
Oh, yeah, take the PD off. I mean, well, I don't know, because even if he called, then he'll just substitute in.
Okay, thank you.
Uh-huh. Sometimes, yeah, okay. Is this Mr. Kyler?
Yes, ma'am.
Thank you, sir. This is 2021 CF 3748. And we can appoint the public defender, sir. They had enough information in regard to this warrant to charge you with robbery with a firearm and a mask. And I'm trying to figure out how many if there's more than one count here.
There's 2 counts, Your Honor, because it was
Two different ones.
stores.
So there was East Colonial and then there was Edgewater, I think.
Yes,
On the same
7-Eleven
day.
on Colonial, and then,
24th of March.
yes, Your Honor, approximately like 5 minutes apart.
Right. Okay. So, sir, right now, those are first-degree felonies punishable by life imprisonment.
Your Honor, state is asking that you hold him no bond pending an Arthur hearing, as they are both punishable by life offenses. I believe he has multiple others pending in Lake County.
He
as well.
has, I think, somehow they released him on his own recognizance out of Lake County. I don't know how that happened unless it was a 33-day motion or something, but anyway, he's got some in Lake County. Other than that, he has no history. But, sir, they have enough information to hold you no bond at this time. We'll appoint the public defender and let you talk to them about that.
Your Honor, state would ask for no contact with victims or witnesses while he's in custody.
No contact with victims or witnesses, sir. Good luck to you. Mr. Davis?
Yes, ma'am.
Sir, this is case number 2019 CF 11770, and it's a failure to appear warrant. We're appointing the public defender. It's alleged that you failed to appear for court on December 4th on a possession-controlled substance paraphernalia charge. In Division 20, the judge issued the bond at no bond, so you have to go back and talk to that judge about the failure to appear. And that's all I have for you today. Good afternoon, Ms. Burpees. This is case number 2021 CF 6111. It's in Division 20. We'll appoint the public defender to represent you. The allegation, they have enough information to file, is possession of cocaine, bond amount 1,000, possession of paraphernalia, bond amount 100, trespass after warning, bond amount 100, resisting without violence, bond amount 100. If you bond out, make sure that you make all your court dates. You probably want to talk to the public defender so they have a decent chance of representing you. The state's going to ask that you not have any drugs that are not prescribed while you're out on bond. And that's all we called you down here for, is to tell you the charges in the bond. And
Your Honor, state would also ask for a no return.
okay, don't return to the scene. Good luck.
Thank you.
Okay. Mr. Florent, is this one that we had a whole bunch of discussions about yesterday?
Your Honor, I believe Ms. George had a PC argument yesterday. He broke into an apartment.
I remember it. Did you call the cop and tell him to add more, or did they just do that anyway?
I did not
Okay,
contact
so-
anybody about this
Yeah,
case.
but I got a better picture of it.
The
Yeah,
main,
he's really breaking in and just tearing everything up.
Your Honor, the main reason yesterday you didn't find PC for the Berg dwelling was because the items that were torn up in the apartment, it said referred to a previous incident. We assumed that meant somebody else or some previous something. And these affidavits, it actually alleges that he actually is the one that did
I
it.
get it, I understand. I remember the arguments yesterday, and I remember looking at this and going, well, he really was breaking in to create carnage. Well, sir, although they put $5,000 bonds on this, what, were you arguing for PBL yesterday?
No, Your Honor.
Oh, okay. Oh, no, we were talking about it being more like a trespass than a burglary.
You found PC for a trespass.
All right, yep, okay, so, sir, now we got more. We got more cases for the court reporter, 2002-1 CF 6131. Counsel, that's going to Division 14. 2002-1 CF 6142. That one is going to Division 20. Folks, sir, it really looks like you've been actually entered in these facilities just to tear up everything. And that, that's a legit burglary. I'm going to find that it's legit. Yesterday, I was worried that you're just breaking in and sleeping in places, and but today, with everything here, I'm going to find that it's a legit burglary, at least probable cause. You can batch them up all together. They'll listen to your lawyer, probably look at it as a package deal. Everybody's going to be wondering why you want to tear everything up, but you've committed all kinds of stuff that is very expensive for them to have to deal with. I'm going to find probable cause for burglary, On the first one, 6131, count one is at 5,000. Criminal mischief is fair at 1,000. You've just been tearing up the place. Plus trespass, count three at 150. And other case is the 6142, find probable cause and leave it at 5,000 on burg dwelling and 150 on the criminal mischief. Good luck with that.
Your Honor, on both, state would ask for a no return and no contact with victims or witnesses.
Right. I think you've got him where he can't hurt anything for a little while, and hopefully he's thinking about it, and they'll figure out what's next, sir, downtown. All right, Miss Giamo?
Yes, ma'am.
Not sure if I said that right, I apologize.
Yes, ma'am, you did. May
Close
I
enough.
say something, please? I
You
have.
might want to talk to your lawyer first, because you might accidentally incriminate yourself.
Sorry.
She doesn't want you to speak until she knows what you're going to say first. I don't have a PD form, but I'm going to point the PD on 2020 CF 13671. Oh, okay. Oh, it's a FTA, thanks.
Talk from a TV court.
Oh, okay. Division 19.
My leg, I've got to get them out, and I have no way to bond out. Yeah, she told me I didn't have anything for days.
It's a failure to appear, counsel, from May 20th. That judge said at no bond. This is pretty normal, you know, maybe some
I
people get
didn't
caught
failure
up.
to appear. I've been calling every day. I promise you that. I called every day. The lady that I spoke with Friday told me that I didn't have any court date until June, that I would have TV court. I never would failure to appear. Ma'am, I have 5 blood clots in my right leg, and I was going to surgery yesterday when they picked me up. The lady's name, I want to say, like, it started with an A. It was Ingrid Ongra, something like that. But I would never failure to appear. Ma'am, I have a
Can you
very serious
possibly
problem in my
just
leg.
Email the trial counsel and see if they can.
Excuse me?
I can't touch this bond. I've got to depend on the lawyers to try to get you in.
What do I do?
I can't touch this bond.
So I'm not going to get out.
I'm not going to touch the bond. I don't touch them. Those felony judges do not
my
want
God.
us to touch their failure to appear bonds. I'm sorry. You have to talk to them. Hopefully the public
So what,
defender
I don't
can
know
get
what
you
I'm
sooner.
supposed to do. So I have to stay in jail till when?
Hopefully the public defender can get your other lawyer downtown to bring it up right away.
Oh, my God.
Mr. Hawkins?
Yes.
All right, sir. This is 2021 CF 6147. We're going to appoint the public defender to represent you, sir.
Yes, ma'am.
And it's going to Division 622. I guess we've got more than one case here. All right, the Division 22 is from yesterday. And they had enough information to file the charge of possession of alprazolam, count 1, bond amount 1,000, and possession of controlled substance, count 2. We'll put that as a subsidiary count of 150. There was another case in Division 19, it's 21 CF 6118. And that's in regard to a warrant that had been signed by another judge in regard to sale or delivery of alprazolam. That was from April 29th, and I think that might have been an undercover transaction that they filed later because they don't want to arrest you right then when it's an undercover deal. So for the sale and delivery, that one is at 7,500. We are appointing the public defender, sir. We have two different cases, and they will help you get those through the system. The count two, the subsidiary, yeah, I made that 150, thank you. Mr. Hornado Salas?
Yes, ma'am.
Thank you, sir. This is case number 2021 CF 4623. We're appointing the public defender to represent you. Case is going to Division 11. And it was in relation to an arrest warrant that was signed by another judge with some pretty high bonds, who found probable cause and set bonds for traffic in fentanyl, more than 4 grams, sale and delivery of cocaine, unlawful use of two-way communication device, which is basically using your phone, for sale and delivery. Now, sir, these bonds come in really high. Count one is coming in at 100,000. Count two is coming in at 7,500. Count three is coming in at 1,000. And I, long ago, decided I was going to let the judges downtown figure out how much they were going to do on these drug bonds. I'm sure you have, your lawyers know what your judge and what is common down there. This is the way they come in. Obviously, it's a little controversial about, the war on drugs and how many people get locked up for it, but I'm going to let them deal with it downtown.
Ma'am, can I say something for the record too?
The lawyer wants you to not say anything because you're at risk. You are at risk at really going to jail for a long time.
I'm not risking nothing. All I want to know if it's this warrant was issued and signed by the judge on April 14. Why did after April 14 I've been pulled over and everything? I caught a traffic violation and never been arrested for this warrant.
I don't know when the officers submitted it into the system to be picked up when the officers run teletype. These guys, they do paperwork,
It was
whether.
signed and issued on April 14th, ma'am.
That doesn't raise my suspicions at all. All that means is it sat on somebody's desk for a couple weeks. That's just no big deal. That's not a defense. It's not suspicious at all.
Your Honor, state would ask that he comply with 903.046 sub 2 sub F. That's the statute saying that he must provide an affidavit to the court when he bonds, saying that the funds are not from illegal means.
I'm not assuming he's getting out anyway. I just want the judge downtown to deal with all that.
What was that she said?
It's a whole nother situation she wants to put on you, and I said no. We have a lot of cases, sir. We need to move on.
And when's my next court date?
I don't know.
Jackson refused court, Your Honor.
All right, I've got a little stack for them that we'll get back to. Is this Mr. Jenkins? Okay, sir. All right, sir, we have 2021 CF 4803. We'll appoint public defender to represent you for now. And it was in relation to a warrant. The case is going to Division 11, and the officer swore out in a warrant that another judge found probable cause for uttering forged bills, set the bond amount at 1,000, which is a typical bond for that, sir. If you do bond out, make sure you come back to court for your court dates. Check in with your public defender so they can have a good chance of defending you. That's all I had for you today, sir. Uh-huh. Is this Mr. Johnson? Sir?
Yes, ma'am.
Okay. All right, sir, we have case number 2019 CF 9637. Will appoint the public defender if they were not previously appointed. John Mills? Okay, you already have a private attorney on this. And it's a failure to appear warrant for an aggravated battery on a pregnant person, allegedly failed to appear for a trial management conference on April 15th. And it says no bond until you get back in front of that judge in Division 22. That's fairly normal. All right, good luck to you, sir.
When that court date will be?
I don't honestly know.
Don't know?
No, I mean, every judge has their different pretrials and so.
No, I was asking when the court date.
I know, I mean, John Mills will tell you, but I don't know. Too many to keep up with.
Did we skip Stephanie Jackson?
I think was that one that he said she refused? And
Yes,
so
Your Honor.
I put her, I've got two in the stack for who refused, and we'll just get them after we get the line down.
Thank you, Your Honor. I missed that she refused.
Okay. We just did them?
No, it's Jackson.
All right. All right, so we're at Mr. Lewis. Sorry, Mr. Lewis, we've had so many today, we're already starting to see stars. At least I am. But this is 2021 CF 6085, and we'll appoint public defender. And it's going to Division 15. Counsel, sir, another judge found probable cause on alleged home invasion robbery with a firearm and grand theft.
Your Honor, due to the nature of count 1, state asks that you hold him no bond pending an Arthur hearing and give reasonable bond on count 2.
Allegedly May 22nd. Sir, generally speaking, for that particular charge, that would be no bond at this point. I'm just reviewing it.
It was the early morning hour or late night hours of May 21st into the early morning hours of May 22nd.
Yep. Sir, this one comes in no bond on the home invasion robbery with a firearm. And they put that on the grand theft also, but talk to your lawyer if you want to have a bond hearing about what you're really looking at. Ironically, no criminal history, so that's amazing. But it's a really large charge. So talk to your lawyer about that.
Your Honor, the state asks that you set a bond on count 2. He is entitled to a bond. I don't believe we can hold him no bond.
Okay, 150 on count 2.
Thank you. State would ask for no contact with victims or witnesses
So ordered. Thank you.
and a no return.
So ordered, even though he's being held no bond. Maybe he could teletransport to the scene.
If they do another hearing and they don't set conditions, I just want.
All right, okay. Is this Mr. Loggins? Thank you, sir. We have 2021 CF 5432. We're appointing the public defender to represent you. It's going to Division 14. And I didn't get down to the arrest affidavits this far. There is a warrant, the sex battery. The original bond was set at $100,000. Probably ought to look at that. I don't know what the judge said. Okay.
Your Honor, it is an F2, so he is entitled to bond. State asks that you stay the bond as it's currently set. The facts in the affidavit are pretty egregious. And there is some corroborating testimony from the defendant himself near the end of the affidavit at the bottom of page 2. So I just ask that you stay the bond as set.
Your Honor, I would just ask that you consider reducing the bond amount in this case. My client does work currently full-time, and he lives here in Orlando. He's not a flight risk, so I ask that you take that into consideration.
Okay. And unfortunately doesn't have, he's got a couple bat Leos, but other things are mainly drugs. Willis, maybe it's some theft. And his partial admission in one of the text messages was, that he didn't know, he just doesn't remember because he was on some pill or something.
And then on the phone call in front of the officer, when the victim asked why he did that to her, he responded, "I don't know."
Right. But at least it's not like some cases we see where there's an extensive history of violence. All right, sir, I'll put bond at 10,000 instead of 100. No contact with her at all. Any text message, evidently you had a little teeny bit of a relationship for a short period of time, but at this point, no contact at all, or you'll just be no bonded if she tells the police that you so much as look at her. Don't return to the scene or where she lives, or where she works. Don't try to get through to her through anybody else indirectly. This might have predated, let's see, the resisting an officer. Oh, that was a 2020 he's out on bond for?
Yes, Your Honor.
I'm not seeing it. It's not pulling up. I can't see.
No, it was a felony and they dropped it down to a misdemeanor, but it's still evidently going on, I think. You bonded on the should we look up? He's saying he thinks he's,
Your Honor, it's still active. He had pretrial May 3rd. 21 MM 115, which was.
You don't know about it. Did the PD waive his appearance on that?
Yes, Your Honor, he's, the reason it hasn't been resolved is he's actually working on getting his license. If you hold him here at no bond on the drive-in, he won't be able to get the license, which is what the court is allowing him to do. So I'd ask that if you are inclined to revoke, that you revoke and double the bond amount, as opposed to holding him at no bond, so he can continue to work on getting his driver's license.
So he originally, they don't have, what is the bond amount? They ROR'd him.
It came in 1,000 on the fleeing and attempting to elude, 500 on the dwellis, and 500 on the resisting. We only filed on the resisting and the dwellis.
It looks like a prosecutor filed a null pros on May 11th and May 12th. You want to see it?
And this was done in court.
I don't have anything in my system.
Yeah, I can't pull it. It's saying closed for me. I can't see anything.
ROR on count 2 and count 1 was no problem.
Okay, ROR don't, what does it say? Okay.
It was sent back.
Oh, David, well, if both of them say not pros. But the clerk, both of them say. strange. Okay, so I think they now processed the resisting, and they ROR'd him on the Dwellis.
That's what I see, Your Honor. I see a diversion on the resisting and the Dwellis is still open.
But I don't see what the next court date is either. Yeah, get your license. Well, that would, no, all right, so, but, they don't drop it just because. They drop it later after you get your license, okay? So figure out what your court date is.
You're gonna take no action?
I'll take no action on that, not because it doesn't matter. If you get a new charge while you're out on bond, you oftentimes will get revoked on the one that you're out on. I understand the trying to get a license, and that's why you got the job. Maybe there's a good reason to get a job anyway, but definitely to get your license back, so you get your life better straight. So, but I lowered the bond to 10,000 on the sexual battery, and I appointed the public defender. So make sure you come back to court on the driving with license suspended, and also on the sexual battery case, no contact with her whatsoever. If you have any guns, knives, or weapons, put those in the care of the law enforcement agency that arrested you within 24 hours of your release. You're not allowed to have a gun or weapon while you're out on bond for this kind of case. All right, good luck. Ms. Lomelli? Okay. This one bonded. Thank you. Is this Ms. McMiller Simmons?
Yes, ma'am.
Okay. This is case number 2020 CF 11540. You might have previously had the public defender, but we'll point him if you didn't. And it's in Division 20, a failure to appear warrant on a possession of cocaine. It was a pretrial conference supposedly on the 17th of this month, but the judge set the bond at 500. So I think that means that they just wanted you to be reminded to come back to court, post bond, and then come back to court, keep track of your court dates. If you have trouble, you can always look them up online in the clerk system under records and input your name, and you can keep up, even if you lose the paperwork.
Yes, ma'am.
Okay? And that's all we had for you today, ma'am. Is this Mr. Parton?
Yes, ma'am.
Thank you. All right, sir. The newer case is, thank you. 2021 CF 6158. It's going to Division 16. We can appoint the public defender. The allegation is possession of cocaine with intent to sell. Second. Give me a second, I didn't get this far. Okay, that's a kind of factual circumstance they can generally sustain at least a probable cause finding of possession of cocaine with intent to sell. Is that the usual bond now for that?
Due to the intent to sell and deliver, yes, Your Honor.
And Your Honor, I would ask that you consider lowering that bond amount.
You know he's out on bond for
Oh.
3 things,
Yeah.
right? Including delivery of cocaine.
I would also argue 20 pieces of crack cocaine and then 10 more is a significant amount.
All right, sir, given everything else you got going on, I don't see, if it was just one case, I might look at it, but 15,000, they're telling me, I'm a substitute judge now, but they're telling me that's normal for this now. I'll leave it at that. You got 3 cases pending, and that's a problem, getting a new case while you're out on bond. Let me find which one they are. You got, possession of drug paraphernalia on, case number 2021 MM2223.
On that case, Your Honor, it came in with other charges. We only ended up filing on the paraphernalia. It was a $500 bond.
Okay.
Unless you're inclined to just revoke outright, state would ask that you revoke and double.
Yeah, we'll just revoke and double it to 1,000 on the misdemeanor. The next one is case number 2021 CF 1387, and he might have been on pretrial release for that delivery of cocaine, because I've got a notification of pretrial release form.
He was on pretrial release for that? Was he on pretrial release and bond? No? Okay. Your Honor, as it is the same exact charge, I'd ask that you revoke PTR and set it at the appropriate bond.
The case number on the PTR paperwork is 2021 CF 1387. We're all a little bit mystified about being on PTR for delivery of cocaine. But that's what the jail staff has given me. So he's already got 15,000 on the first one. Let's put 7,500 on this, which is what I'm more used to. Okay. And then there's 2021 CF 1401, and that's in Division 19. It's an alleged carry and concealed firearm by a convicted felon.
Bond was $5,000, Your Honor.
It was?
Yes.
All right, let's double that to 10, sir. That's what we typically do. You know, I hope you make some different decisions in the future.
Thank you, Mel.
You're welcome. All right. Thank you. All right, then is this Mr. Pierre?
I'm sorry?
Mr. Pierre?
Yes, ma'am.
Okay, thank you, sorry. All right, we have a new case of 2021 CF 5860, appointing the public defender, and it's going to Division 15. The allegation is possession of firearm by a convicted delinquent. And it was the subject of an arrest warrant and an affidavit in regard to some, an incident from the 7th of May. He got ROR'd on an attempted second-degree murder with a firearm.
No, Your Honor. I believe there was a KPS. They had a hearing. They withdrew the KPS and reinstated bond in April 28th of 2021.
He's got a trial date.
There was a trial date as of May 3rd, but defense depositions are scheduled June 10th. We ended up filing the attempted second, possession of a firearm by convicted felon, and aggravated assault with a deadly weapon.
Looks like he's got a trial date of the 7th of June, or at least the trial period starts.
That's probably when the trial period starts, Your Honor.
So he's, now the bond, the clerk's paperwork says ROR, but you have him on some kind of bond for that? And the date of arrest was October, and he was bonded originally in November. He could have been a 33-day motion and then, but you have him on bond now.
I believe so, Your Honor.
They're telling me it's ROR, but
Your Honor, given,
It was our
it must have been a 33-day motion.
2020.
I don't see any 33-day motions in here. Your Honor, given this, the out-on-bond case happened before the case that he has in a warrant for now, state would just ask that you revoke his out-on-bond, given that they're both firearm offenses and both violent in nature.
Okay.
Your Honor, I would ask that if you are inclined to revoke, you are revoking double the bond amount.
All right. Let me look at the new one. Noted. Oh, they were at a gun range.
Yes, Your Honor.
Okay, so evidently, he's charged with going to the Shoot Straight gun range after he'd been a convicted delinquent, told not to possess a gun, and was out on bond, or ROR, when evidently this, maybe state didn't file their paperwork fast enough on an attempted second-degree murder with a firearm.
Yes, Your Honor.
Possession of firearm by convicted felon or delinquent, and aggravated assault with a deadly weapon. Okay. Well, sir, I'm going to go ahead and, what's the normal bond on possession of firearm by convicted delinquent?
I think it's 4 or 5
Like
thousand.
$5,000 usually?
I think so. It's 4 or 5.
Okay, let me, on the new charge, 2021 CF 5860, they got you on video supposedly. I guess the police officer realized you were there. They have video in these places, surveillance videos, and the cop later went and found out that you'd gone down to the gun range when you'd been told not to. That's a $5,000 on count one. I don't think the judge would mind that. Possession of ammo by convicted delinquent, let's put that at $150. So that's a normal bond amount. But the other one that you were out on ROR for, I don't think you let you out because you didn't have to worry about it anymore. I think the state didn't file their paperwork on time. I'm going to revoke that and put it at no bond, let you go downtown with your public defender and talk to that judge about supposedly getting caught with a gun again after you're out on bond or ROR for attempted second-degree murder with a firearm when you have previously been convicted and you're not supposed to have a gun. We're all worried about kids getting killed. You know, I mean, it's almost like every day out there, some other kid gets killed. Good luck. Your public defender don't want you talking about it. Talk to your lawyer in private, sir.
He does have a private attorney on the murder case, Your Honor.
Okay. Probably conflict, maybe?
I'm sorry?
Maybe a conflict even?
I'm not sure, Your Honor.
No, Your Honor.
I just know it's a private attorney.
It's a private, it wasn't a conflict.
Okay. We have Mr. Pills. Okay. Let's call that up in a few minutes, then. Is this Ms. Prevault?
Yes, ma'am.
Thank you, ma'am. It's 2021 CF 6163. We can appoint the public defender to represent you. Thank you. Updated face sheet. Doesn't actually qualify for PTR, so because they reevaluated something. It's going to Division 22. The allegation is possession of cocaine, count 1. And it looks like they have enough information to file the charge at bond amount 1,000, possession of paraphernalia, count 2. We'll make that a subsidiary bond amount of 100 instead of 500. Appointing the public defender, give you some court dates to come back. The state wants me to always tell you not to have any non-prescribed drugs while you're out on bond. Okay, this is 2002-1 CF 6157. Is this Ms. Ramos? All right, thank you, sir. We can appoint the public defender on your case. And the allegation is, it's in Division 11, counsel. The allegation is trafficking of cocaine over 28 grams.
Yes, Your Honor.
Another very short police report.
And Your Honor, he does qualify for pretrial release. He has no criminal history, so I would ask that he's placed on pretrial release.
Your Honor, state would object. He had 39 grams of cocaine on him, which is an extremely significant amount. I understand that the charge otherwise qualifies, however, I do not believe it's reasonable.
I didn't know that trafficking was one of the qualifying charges.
I didn't know either, Your Honor. I believe this is the first one that's ever qualified.
It's a nonviolent offense.
Okay, so we're between 50,000 and 0. He doesn't seem to have prior history. Amazing. Wow. He passed the stop bar. I still freak out whenever I pass the stop bar because I know you can get stopped for that. And then the ubiquitous odor of cannabis that evidently every single car that the cops ever stop has the odor of cannabis. There must be, everybody out there must be stoned while they're driving, which also freaks me out. Well, sir, holy cow.
And Your Honor, I would just point to the fact that in the arrest affidavit, it states that it was for personal use.
Can you speak loud enough?
Sorry, it was for personal use is what's mentioned in the arrest affidavit.
39 grams?
That was the
Yes.
defendant's own statement, Your Honor. I believe
Yeah.
that was a statement to.
Correct, Your Honor. However, his criminal history does indicate that that may be, very well be the case. So I would just.
Okay, y'all stop a minute. I'm going to read this one more time and try to see if there's anything that jumps out at me on this page.
Okay.
So he gets stopped by the stop bar, cannabis, and he told him he had some cocaine, and he said it was for personal use, and it was 39 grams. Wow.
And he's cooperative, Your Honor. So.
Okay. Well, maybe somebody just, he's doing it for somebody or something. It doesn't make any sense that somebody would just suddenly have that much. His mother verified his employment. He's 23. He's been on leave from work for 2 weeks. So jail staff has verified that he lives here. Has he lived here for a while? 1 time or 1 year or longer?
Yes, Your Honor, he stated yes.
Born in the U.S. Okay, sir. I don't know who you were doing this for, but whoever it is about getting you to be sent to prison if you're not careful.
Your Honor, if you are inclined to put him on PTR.
No.
I would just ask for bond and PTR for the supervision.
I'm inclined to do 10,000 because he's got absolutely no history at all. And something tells me he's doing this for somebody else. His mother's probably going to bond him out. It's just a guess, but it's the best I can do right now. But I can't go with PTR.
That's good, Your Honor. Thank you.
Sir, you're in a heap of trouble. Just make sure you come back to court. Mr. Robinson? All right, sir. We have it's over here. I know they look like a judge, but I'm over here. It's confusing when you come in here, isn't it? In addition to being scared to death. All right, so this one is case number 2021-CF488, and we'll appoint the public defender, sir. It's an additional charge. It's I think, it's a failure to appear on a possession of alone, allegedly a case management conference from May 20th. The bond is 1,000 on this one. It's in Division 22. I don't happen to know if you have some other things pending, but this one is at 1,000 for the failure to appear. And that's all we have for you today.
All right.
Thank you. Okay. Thank you. Is this Mr. Rushing?
Yes, ma'am.
Okay, thank you, sir. We have, is it one case? Might be two.
There's two, Your Honor.
All right. We have case number 2021 CF 4823 in Division 20. Will appoint the public defender to represent you. So that's an alleged failure to register as required in regard to sex offender status. Currently, is that supposed to come in? Those come in no bond sometimes, don't they?
Yes, Your Honor.
And it was alleged that you were convicted back in 2014 and that they, you are under continuing obligation.
Your Honor, he also pled to this in 2020.
All right.
He pled to failing to report in 2020.
All right, so evidently you weren't reporting and they found out where you were. Then I think there's come in no bond, sir. I think you go downtown and figure out what your bond is going to be on that.
Your Honor, you can set a bond on it.
What was a bond that gets set on that? Is it like $5,000 or something?
I believe when it came in, his prior case, it came in as $5,000. Due to him just playing to one and knowing the reporting requirements, I would ask for you to double it. I'd ask for 10.
You might as well set them at no bond at that point, Your Honor. I would just ask for the 5,000 in this case.
The allegations are serious, Your Honor. There are reporting requirements for a reason. And again, he just pled to this.
Your Honor, I would like to say something.
You want to talk to your public defender first, sir?
Your Honor, the only reason he pled to the last one was because when he was at work, the officer came to check his residence because he was at work. So, Your Honor, I would just ask that you not set the $2,000. He's not going to be able to afford it. And he's going to lose the current job he does have.
He does have private counsel as well, Your Honor. So he is affording private counsel, so I think the bond is reasonable.
And, he evidently has enough money to get some cocaine, the weight of 7.4 grams in a digital scale.
Yes, Your Honor, there's also that.
Clerk wants to know which case he's got the private attorney on. Is that the reporting requirement case?
And his underlying private,
Oh, the other one.
the one that he just pled to in
All right,
2020.
he's 26. His mother's probably paying all these. Sir, I'm going to set the bond at 5,000 on the reporting requirements. The cocaine possession, they have enough information to file that also. I guess they wanted no bond because they knew about the other case or something. It's a significant amount. Let's put 5,000 on the possession of cocaine also. No drugs while you're out on bond. Make all your court dates. Good luck.
And maintain reporting requirements.
Maintain reporting requirements. Is this, okay? I'm having trouble with the barcode, but it's 2021 CF 6136 and 6137. All right, thank you. All right, sir. Let's go ahead and appoint the public defender on these. Doesn't look like he's got any prior criminal history. He might have some mental health issues and needs to take medications. In regard to 21 CF 6137, that's going to Division 10. An alleged attempted burglary of structure and criminal mischief. That's in regards to these pulling on the door handles.
I think they broke off the door handles, Your Honor, with a socket wrench.
Okay,
He qualifies for pretrial release, Your Honor.
all right. Finding probable cause on that. And the other one, grand theft motor vehicle, is 21 CF 6136, that's Division 19. So that's enough information to at least file the charge of grand theft motor vehicle. We'll go ahead and authorize pretrial release, sir. Make sure you come back to court for your court dates.
Yes.
And we'll appoint the public defender. You might want to talk with them so they can be well prepared for your court dates.
Your
This
Honor,
this is not to minimize anything, but you don't have much criminal history, so we're more likely to lock up people who have had prior criminal history. Yes, ma'am?
the state would ask for no contact with any victims or witnesses and no return to any of the scenes.
All right. So ordered. Mr. Slater? Okay, thank you, sir. We have case number 2021 CF 6115. Public defender is appointed. It's Division 12. The allegation is burglary of unoccupied structure, petty larceny. Parking garage. Right. Looks like they do have enough information to file that charge, sir.
Ma'am,
You might want to talk to the lawyer. They have enough information to file the charge. Burglary is even when you go into like an enclosed area, supposedly to take something, it becomes a burglary charge.
I never entered.
And the bond amount is $3,500 on that. There's video surveillance to show what really happened or didn't happen once they really look at the case. The bond is $3,500 on the burglary and $100 on the petty theft. We have given you a public defender. Make sure you talk with them. Don't return back to the Rollins campus. They probably have a trespass warning.
150, the 150
3,500 and 100.
and 100.
Okay, is this Miss Stewart?
Yes.
Suddenly having trouble with the barcode. Okay, thank you. This is 2002-1 CF 6150. We're appointing the public defender to represent you. And it's going to Division 15. It came in as an armed trespass of structure, aggravated assault with a deadly weapon. Let me go ahead and look at that. The clerk has put a page in there that is sort of a bond correction form. Okay. Okay. Now, the clerk says they think the ag assault charge with a deadly weapon is 1,500. She's got prior battery, transport employee, couple robbery arrests, assault, multiple VOPs, trespasses.
Your Honor, the state would just ask that you stay the bond as the clerk has set. 15 on one and 150 on two.
I don't mind staying them. I'm more inclined to hike them. But I'll go ahead and stay them this time, ma'am. Go back to that place. They have a trespass warning. Now you pulled a box cutter on the guy, threatened to slice him, according to the police report. Any contact will
There was no contact.
I'm sorry, so you're gonna, leave the 1,500 on the aggravated assault and the 150 on the armed trespass?
As will the clerk or your paperwork said that was a
Inmate.
correction.
Yeah, inmate records, did that correction.
Okay, that's fine. I'll go ahead and stay it at the correction. I think it's a little low for assault with a deadly weapon, but, ma'am, if you have any contact at all, it'll just be no bond. Don't go back there, or it'll be no bond.
Your Honor, state also asked for no weapons, firearms, or ammunition.
Any weapons or firearms, put those in the custody of the law enforcement agency within 24 hours of your release. You're not allowed to have weapons while you're on bond for this charge. I did order no contact. I told her it'd be no bond if she has any contact at all. Thank you for asking. I know, it's a lot to keep up with. Okay, is this Mr. Simonette?
Yes, ma'am.
Okay, thank you. I think the barcode's getting tired. 2002-1 CF 5914. Let's appoint the public defender, sir. The case is going to Division 22. And this was a warrant, sir, alleging child abuse. And I don't think I got the affidavit for that. Now, sometimes those are kind of locked, and I don't know if the judicial assistant had access to it.
Your Honor, I have a copy. Would you like it?
Yes, ma'am, thank you. Very much. Okay, thanks very much. Because it was provisionally set at no bond, but that judge usually does it until the IA judge gets to it. All right. Okay. All right. Well, sir, evidently, your son's face was swelling. They took X-rays. Evidently, the bones weren't broken, but his mom's going to take him to the dentist because some of the teeth might or might not be broken. Definitely some pain. The cheek was sort of ripped open. The eyes were swollen, and sometimes that stuff starts to become more noticeable the next day. The teachers noticed it supposedly when he went to school. So there's enough information for the charge to be filed because actually the definition tends to be when you leave marks like that. There's one thing about corporal punishment, but there's nothing about taking it too far and then it becomes a crime, and so that's what you're charged with. So state is definitely going to recommend, and it would normally be ordered no contact for now, except as authorized by juvenile court and/or DCF. We're going to control contact, and the orders of this court will go along with that normally. And there is some criminal history in regard to some violent history. Is there anything the state wants to say about bond?
Your Honor, state would just ask for a reasonable bond, given the facts that you just read in that affidavit. But it's pretty egregious, and the injuries that the child sustained are pretty egregious, so I just ask for a bond that is reasonable with the facts obtained and the defendant's criminal history.
All right.
Your Honor,
Look.
I always argue.
Okay, let me, I think 2,500 would be about the range that would be expected. Sir, the maybe bigger consequence to you is whether or not you get to see your son, but the juvenile court's going to control that for now. Make sure you keep in contact with your public defender and make your court dates.
Your Honor, state would also ask for no weapons, firearms, or ammunition.
Sir, we usually ordered no weapons, firearms, or ammunition while you're out on bond for
And
domestic.
state would also ask for no return to the main address that the child remains at.
So ordered, okay.
I'm sorry, I'm sorry.
So when you're out on bond for domestic, we usually tell you not to have any weapons. If you have any weapons, put them in the custody of the law enforcement agency within 24 hours of your release, because you can't have weapons while you're out on bond for domestic or charge. And state's asking, don't return to the child's mother's residence for now, except pursuant to any orders authorizing that by juvenile court in DCF.
Oh.
Right, good luck. I've still got your affidavit. I can give it back to you when you want, okay? You want to do it now or later, we might forget, right? Thank you. Thank you. Is this Mr. Tavares?
Yes, ma'am.
Thank you, sir. All right, we have, let's authorize the public defender on these cases. Case number 2021-CF6176 is going to Division 14. That's a warrant, which is based upon an alleged sale and delivery of fentanyl and delivery of controlled substances within 1,000 feet of a convenience business. Another judge found probable cause. Basically, no bondage until IAs. And there's a misdemeanor case also, but my inclination quite often is to let them go down to 0.5 grams of fentanyl. But it was a sale and delivery. Okay. Counselor, are these ones going at 50,000 or is this more like 7,500 or 15,000 that I've been seeing lately?
The 15,000, I believe, is the intent to sell or deliver. When there's an actual sale and delivery, I thought it was 50.
50 on the fentanyl?
I believe also due to it being fentanyl, Your Honor, since it's a high potency narcotic.
All right, well, let's set bond on count two, delivery of controlled substance within 1,000 feet of a convenience business. Now, sir, some of these bonds that are coming in on sales and deliveries are pretty high. And although I'm just a substitute judge now, I'm used to just letting the judges downtown figure out what they want to do on those. There's a whole story behind why they're so high. But I think they know what they want to do with these bonds and what's appropriate in regard to public safety and what's really required on these. So I tend to let the judge downtown handle those. But I did set bond. You do have a bond, even though it's a high one.
Your Honor, it's 50,000 for the sell and delivery, and then, I didn't hear what the.
I just put the second one at 150 because, you know, the first one's enough. And the second case is 2021 MM 3554, Division 61, possession of prescription drug without a script. There's 2 counts, and they've got probable cause for that. 500 on count 1. Let's put 100 on count 2 as a subsidiary.
You don't qualify for anything else.
Okay. Is this a, Mr. Trice? Okay. We have 2002-1 CF 6177, Division 19. We can appoint the public defender on that. And it appears to be a warrant in regard to sound delivery of cocaine within 1,000 feet of a convenience business. And that one's coming in at 50,000 also
Yeah,
on cocaine. Isn't that closer to this? They were always high, but they're higher now, evidently. And let's see, he's out on bond for the same thing, so that's a problem.
His out on bond sale and delivery of cocaine, I believe the bond was 7,500.
7,500, which is what I'm more used to, even though some of those have been hiked up in recent years. And then this one is alleged to have occurred do I even have that? I think we had gotten to the point where we ran out of some of these affidavits. I don't have that affidavit. Okay, so this one was alleged to have occurred on about April 23rd. He bonded out on the other one, March 3rd. So this one would have happened after he bonded out. Sir, let me set the new one at 7,500, no bond you on the one you're out on bond for, which I think a lot of times the felony judges expect if it's the same thing that you were out on bond for. You can't get a new charge while you're out on bond. So it probably was controlled by, and the other judge found probable cause on that. We're going to appoint the public defender on everything. Yeah. Okay. Is this Mr. Vidito? Thank you, sir. Let's appoint the public defender. It's case number 2002-1 CF 6164. It's in Division 19. And I think they doubled the bond on this because of being out of state. You might want to talk to the public defender because when you're charged with a crime, everything you say could be played back later at your trial. He wants to talk about something, counsel.
Yes, Your Honor.
Just give me a second. Okay. He was in a guy's car, allegedly.
Your Honor, I would just ask that you consider the fact that my client is on Social Security disability, and consider lowering the first bond amount that's set at $7,000, so that he is actually able to afford the bond.
Well, he doesn't seem to have a burglary background. He's got, some domestic assaults and batteries. Seems to like to have weapons. I was starting to wonder if he even knew which car he was in.
I do not believe so, Your Honor.
What makes you think that, counsel?
The victim ran over to the vehicle and told him to get out of it, that it was his, and the defendant refused to exit. I don't see any notation in the affidavit saying that the defendant owns the same vehicle. And arguably, when I get in my vehicle, I know it's my vehicle. It has my
Well,
items.
unless
and
you're
smells like my car.
disoriented for some reason or whatever.
Correct, Your Honor.
He also damaged things inside the vehicle, Your Honor, which you wouldn't do if it was your own vehicle.
Well, there's a plastic piece that was on the ground but was reattached and not broken. One of those plastic pieces that's removable and you can put it back. All right, and he's from Massachusetts, okay. Sir, if you don't come back, there'll be a warrant out for your arrest in Florida. What do they put this at? 7,000? I'm going to set it at 2,000. I think it's ultimately going to be filed as something different, but I don't know. It's hard to figure out what he was intending, what crime he was intending to commit while he was in there. So just 2,000 on count one and 100 on the trespassing. I know we generally double it because he's out of state. I don't. If he doesn't come out or back, he'll just have a warrant out, and hopefully 2,000 and will protect the bondsman to some degree.
Your Honor, state would ask for no contact with victims or witnesses.
Yeah, no contact with victim or witnesses, and don't return to that scene. They probably have a trespass warning out for you now. Mr. Wells? This is 2021 CF 6166, also out on bond. Sir, let's appoint a public defender, this case going to Division 16, and it looks like a possession of methamphetamine plus some ammunition where they charge you each piece of ammunition, which you're evidently not allowed to have when you're a convicted felon. And let me go ahead and look at it real quickly. Okay, looks like they have enough information for the charges. Yeah, where's the? All right. And also being out on bond for possession of controlled substance, false name, dwellers, identity theft. Okay. Getting tired of it. Is 5,000 usually for possession of ammunition?
Yes, Your Honor. State just asked that you stay the bonds as set.
I'm asking her because I'm a substitute judge and I haven't done this for a few years. And he's got 2,500 on possession of controlled substance. All right, well, sir, let's go ahead and appoint the public defender on everything, stay the bonds on the new one, 5,000 on count one, 150 on each of count 2, 3, 4, possession of ammunition, and count 5, possession of methamphetamine. And double the bond on the one you're out on bond for, 2020 CF 9484, instead of no bonding you. You've been bonded out since the 17th of December on that. You've got a return date of the June 30th on that. Maybe they can put them all together. That's a possession of controlled substance, count 1, given false name, count 2, driving while license suspended, 2 prior convictions, count 3, and 4, identity theft. It comes up to 2,500. I'm not sure about the individual.
Your Honor, there is no count 4.
There's no more
We
count.
filed possession of a controlled substance in F3, a giving a false name to adversely affect another in F3, and a dwellis subsequent M1.
Okay,
I believe the possession of a controlled substance probably came in at 1,000. The giving a false name was probably 1,000, and the dwellis was probably 500, if I had to guess.
hard to say because the bond amount was 2,500. So can we ixnay count 4 because it no longer exists? 1 through 3, if we double those, then I think the felony judge will be satisfied that we did something, because you're not supposed to get a new charge while you're out of bond for the other charge. Well, I don't have information on what they individually were. We're yes.
Possession of controlled substance is gonna be 2,000 now. Giving
Okay.
false name is gonna be 2,000 now. And the driving is going to be 1,000.
All right, that's about where I thought it would be. Thank you for that details. Sir, so you got some bonds. Hope you can get out. If you can't, your court date is the June 30th, and you might be getting some credit for time served for both of them at one time, and maybe that would be helpful. That's the best I can do for you today. Is this Miss Wilson? Okay. Ma'am, we have case number 2021 CF 6109, 6110 are the new charges, and looks like a felony dwellis that you were out on bond on. Let's go ahead and appoint the public defender. And the new charges, the one going to Division 11 is another driving while license suspended. (6110) and what's 6109 is possession of cocaine. All right. The cocaine's going to Division 14, the dwellis is going to Division 11. Let me read it real quick. I don't know. All right, looks like they got probable cause for those. let's appoint the public defender, stay the bond on possession of cocaine at 1,000, stay the possession of controlled substance at 150. That's on the Division 14 case. On the Division 11 case, which is 6110, driving while license revoked habitual, we'll stay that at 2,500. The one that she's out on bond for, so driving with license, suspended habitual, she was at 500. And she has a court date of 5/28 on that.
Your Honor, I would just ask that you double the bond amount to 1,000.
Let's double the bond amount. I don't know if you get out or not, ma'am. If you don't, you'll be getting some credit for time served. Since you're racking up some charges, that might be convenient for you.
Double to be 1,000?
Yep. Okay, we had just a couple of, or two or three, that we didn't have in court today. The first being Rictia Corbin. Which is an add-on, I think, 2002-1 CF 6148. We'll appoint the public defender.
I don't think she has any other cases, Your Honor. I don't believe that it's an add-on.
It's not really an add-on, okay?
Your Honor, I just ask that you take into consideration, I don't know if you read it. Were you able to read this one, Your Honor?
Sure, it's a Division 11. Go ahead, counsel.
Take into consideration the facts. It does seem that the alleged victim did sign a declination, and stated she does not want to press charges. It was her best friend. It seems more like a false imprisonment from where I stand. However, if you are finding PC for the kidnapping, Your Honor, I just ask that you take that into consideration with setting the bond, looking at the four corners of the arrest affidavit.
Yeah, it does make you wonder what the heck was going on. She took her best friend's car with the two kids in.
And it seems that it says she was incoherent, emotionally mumbling. So I'm not sure
right.
she's not
And,
here
The
today.
jail wants mental health contacted, so she might be having a mental health problem.
And I believe she refused today, Your Honor. State would just make the argument that it is a punishable by life offense. It does arguably exactly mirror the kidnapping statute. The children were present in the car. The victim knew, or the defendant knew the children were present in the vehicle when she took the vehicle. And when tried, she never came back. She had to be hunted down to be able to find the vehicle and the children. The victim's mother provided the locations that she believed she may have been at, and that's when law enforcement was able to find the children. So state would just ask for no bond, but understanding that you're most likely going to grant a bond, would ask for a bond that is in keeping with this being a first-degree felony and a punishable by life offense. I understand that the victim said at the scene that potentially she did not want to prosecute. However, that does not mean that she will not want to, and does not mean that the state will not be going forward, as there were children taken against their will.
Okay, in regard to the first appearance information sheet, there's no information about any arrests or histories before. Is that because she wasn't interviewed or something? Or does she really not have any criminal history?
She doesn't have any criminal history.
No criminal history. All right, probably something was wrong with her.
Yes, Your Honor, that's why I'm asking that you set bond.
Okay. And, finding probable cause on the kidnapping, okay. It's a little bit technical, maybe it's really a false imprisonment, maybe it's whatever it was.
She does have a petty theft from 2004 and a dwellers without knowledge from 2017 and a dwellers with knowledge from 2017. So she has minor criminal history.
Right, I understand it's technically a big charge. I don't know what it's going to end up being, other than possible mental health problem. I'll set bond at $2,500 on the alleged kidnapping, whatever it was. It's hard to tell what it was. No contact with the alleged victim or witnesses or children. Don't return to the scene. On the Dwillis, 21 CT 3805, Division 83, appoint the public defender, bond amount 500. I'd say mental health pretrial release, but I don't think kidnapping is going to qualify.
No, Your Honor.
Okay, we have a Stephanie Lee Jackson. And that was 2002-1 CF 6161.
Yes, Your Honor. On this one, based on the arrest affidavit that I read, I would argue no PC. There were no tests done. There were no facts listed in the arrest affidavit by the police officer.
State would just ask for a 24-hour reset, Your Honor.
Holy cow, that's one of the shortest ones I've ever seen.
Your Honor, generally, the officer submits the PC statement instead of the actual narrative, which I'm assuming is what happened here.
I don't mind giving you 24 hours. Let's appoint the public defender. Bond is at 1,000. Maybe she'll bond out, maybe
Yes,
she
Your Honor.
won't. It's Division 19, and if she doesn't bond out, I don't mind looking at it again.
Thank you, Your Honor.
All right. So I guess we'll look at this one tomorrow. Probably. Okay, and then it was Todd Pills was the last one. That one is 2002-1 CF 6116, Division 15. We can appoint the public defender, alleged possession of cocaine.
I'll waive the appearance, Your Honor.
All right, looks like they have enough information to file it. Bond amount 1,000. Was that enough for today?
Yes.
Okay. We'll go ahead and be adjourned. Thank you.
Thank you.